So I apologize, we're a little bit late. I'm going to open the uh, public hearing of the Judiciary Committee. And first, please rise and join me in the Pledge of Allegiance. Thank, with that, whoops, sorry. With that, I'm going to recess the hearings for a moment because some of my colleagues wish to cause.
Mr. Chair, I just want to say that you have to recess it to a specific time. So if you want to say 9 or 10:15.
Sure. No, that's fine. Thank you. All right, so we'll recess till 10:15. Will that Representative Birch, 10:15, that gives you enough time? All right, we'll recess till 10:15. I'm going to call the Judiciary Committee back to order. And because I am the prime sponsor of the first bill, my first duty after returning from being away for a couple of weeks will be to step aside so that I can testify and turn the proceedings over to Vice Chair Mannion, who will chair the hearing on this bill. But before I do that, I do want to welcome Representative Ball as the newest member of the Judiciary Committee. And I know that I'm sure that you've been here for while I've been gone, but this is the first time that you've been here with me. And I just wanted to thank you for serving on the committee.
Thank you, Chairman. I appreciate that.
And with that, I'm going to step aside.
Okay. We're going to open the hearing on House Bill 1130, and I recognize Representative Bob Lynn to introduce the bill.
Thank you, Mr. Chairman, members of the committee. I'm Representative Bob Lynn. I represent Wyndham, Rockingham District 17. And I'm here to introduce House Bill 1130, which makes certain changes to the current law dealing with judicial evaluations. It does several things. First, it defines for the first time judicial officer. It adds components, which I think are valuable components to the current judicial evaluation system. In particular, it discusses in-court observations as being part of the judicial evaluation system. And it also calls for statistical analysis of processing times in connection with the evaluations. It also provides that judicial evaluations for each judge shall be published. I should note that in drafting this bill, I did have conversations with Chief Justice McDonald about this. But I also want to indicate that I received, and I know the letter was, I believe, addressed to all members of the committee. So I hope you all received it. But I received a letter dated January 26th from Judge John Pendleton, a circuit court judge who I've known for years, and he's a fine judge, raising concerns about, in particular, the provision of the bill that requires that the public aspect of the judicial evaluations include the comments that are made by people who are who provide comments as part of the evaluation process. He raises concerns about that, and I have to say candidly that I think that it's, he raises valid concerns regarding that. So I'm happy to answer questions regarding that, and not only regarding that, but really regarding any of the issues that the members of the committee may have. And I also note, I think that there are some representatives of the judicial branch here who may be able to provide information on one or more aspects of the bill. So with that, I'm happy to take any questions.
Are there any questions? Seeing none, thank you.
Great, thank you.
Well, we have one. Oh, Representative Tripp has a question for you.
Oh, yeah, sorry.
Mike's on.
Thank you for taking my question. Could you describe how your proposed judicial performance evaluation is an improvement upon the current evaluation?
Yeah, well, it does. I think what I would say two of the biggest, or two of the biggest improvements are the in-court observations and the statistical analysis of time to disposition. Now, I should say on that I would be interested in hearing from the judicial, what the witnesses from the judicial branch have to say, because I think that may be, the devil may be in the details of that. I think it is a good idea to have an evaluation that focuses on how long it generally takes a judge to dispose of cases. I mean, I think that is a fair matter for evaluation of a judge. It can get complicated in that, if some judges end up in a particular 3-year period having a particularly complex set of cases versus the average judge, that's something that may need to be factored in, and exactly how that would be done is not spelled out in the bill. The bill sort of leaves that to the judicial branch to design that kind of thing, which I think they could do, but I guess all I'm saying is it's complicated. It's not something that, can easily be done in black and white. But I do think that particularly the in-court observations, I think is a valid change to the current evaluation system.
Representative Smith?
Good morning and welcome back.
Thank you.
Can you imagine that you were the Chief Justice of the Supreme Court? I think you can. Would you, how would you feel as Chief Justice of the Supreme Court about you deciding how to evaluate all of the judges in the judicial branch?
I think if I as the Chief Justice had to do that just by myself, I mean, that would be a tremendous.
I'm sorry, I guess I didn't ask that. Well, you indicated to us, that you had conversations
Right.
with the sitting Chief Justice about this. And I'm just wondering about the appropriateness of the Chief Justice deciding how to evaluate all the judges.
I guess, I had conversations with Chief Justice McDonald about this because it was something, that affects the judicial branch, and he is the head of the judicial branch. I thought getting his input was important. I did get his input, and I think that there was not anything. There were earlier proposals that I think would have been positively harmful to the judicial branch, and I think that is not contained in this legislation. Although, as I said, I think Judge Pendleton does raise a valid point about the wisdom of making individual comments of people who submit comments during the evaluation process about making those public.
Could I ask one more?
Sure. Follow up?
Thank you very much. Could you, I sit on the Judicial Council because of your kindness, and have sat on it in the past, and so I'm quite familiar with the efforts that have gone on over the years to improve the judicial evaluation system. Could you explain to this committee who has in the past been considered to be responsible for developing the judicial evaluation system?
Well, it's been a combination of various judges. I mean, I had some role in it when I was on the Supreme Court, and particularly when I was Chief Justice, but it's generally been a combination of judges. I think, in fact, we may have had at various times a committee within the judicial branch to sort of propose um, various ways of implementing the current law as it was initially developed, and then I think it was amended once or twice in maybe 2012 or 13. I don't have that at the top of my head, but the statute was amended, I think, at least once. Um,
Representative Perez?
Thank you. Thanks for taking my question. That confused me. I'm sorry, not lawyer. I thought this was putting together a group of people, not just one person, to do the evaluation. Is that, it's going to be the judicial committee, right? Judicial performance evaluation. That's going to be several people involved in that. Is that correct?
Yeah, well, the way the way the system works now is that there is, for example, that let me just let's take the Superior Court as an example. Each judge in the Superior Court is evaluated every 3 years, and in a sort of rotational fashion, and the Chief Justice of the Superior Court does the evaluations. But what that involves is there are questionnaires sent out to people who have had contact, lawyers or litigants who have had contact with the judge during that period of time. Those questionnaires are sent out. Unfortunately, one of the problems of the system, and I'm not sure, frankly, that to be completely candid, I'm not sure that my bill um, corrects this, because I'm not sure exactly how you correct it. But one of the problems is the lack of although you send out a lot of questionnaires, a lot of people don't return them.
Right.
So you have a small sampling very often of people that return the questionnaires, and candidly, um, many of the people who return questionnaires, just based upon my experience, are people who are unhappy with the decision made by the judge. That's that unquestionably it happens a lot. Although this makes changes to the system, I'm not sure that it's going to be able to fix that problem.
Thank you.
Representative Birch?
Thank you, Mr. Chair, and greetings, Mr. Chair. We're happy to have you back. I have a couple of questions. The first one is, it's my understanding that this bill would contravene the recommendations of the American Bar Association's Committee on Judicial Evaluations, which does not recommend this lack of confidentiality, shall we say. Are you aware of that, and do you have a comment?
I was not aware of that, but I mean, if you represent that that's the case, I don't question your representation.
If I could follow up. I'm sure you are aware that if a complaint is filed against an attorney, it goes to the Attorney Discipline Office that conducts an initial review as to whether there's potential merit or not. And many are dismissed at that stage without adverse publicity to the attorney involved. And only if there's kind of a probable cause or some equivalent finding does it become available to the public. Am I correct in understanding that your bill would not have any of that preliminary screening function to it?
That is true, but I mean, I think the one significant difference here is that both in the attorney discipline system and even in the Judicial Conduct Committee system, the that the purpose of those systems is to investigate misconduct as opposed to evaluating somebody's performance. So I think that, I mean, that is a difference, but I mean, I do agree with you that this would be making the comments of people who submit comments relating to the evaluation of a judge public is a significant change. I completely agree with that. And as I said, I hope you'll all have a chance to read Judge Pendleton's letter. He's a very thoughtful judge. And as I said, I thought it was addressed to the whole committee, so I thought you all received it. But I'm happy to make my copy available to everyone. I'm happy to do that. But he's a very thoughtful judge, and he raises good points on this matter.
If I may, Mr. Chair, it's clear that we didn't, so we would appreciate getting copies.
Yeah. Oh, absolutely. I'll ask.
I received communications from two judges, but yeah, okay. I received communication from two judges, but they did not indicate that they wanted it, their name out there.
Okay. You know what? I have not heard from other judges besides Judge Pendleton, but I'm hoping if there's a sense within the judicial branch of how judges generally feel about this issue, I'm hoping that somebody from the judicial branch who was here may be able to address that, because I don't have that information.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. It's good to see you again and welcome back. I wanted to ask, what are the current provisions for confidentiality under the current system of evaluation, and what changes would this bill make in terms of confidentiality?
Well, under the current system, the judges are the evaluations are confidential. In other words, there is a report that's prepared indicating that judges have been evaluated and what the average score is of the evaluations, but they are not. It's not, Judge Jones. Here is the evaluation of Judge Jones, and here is the score that he received, and here are the comments about Judge Jones. That is not public now. Under this, it would become public. The only exception to that, I believe, under the current law, is if a judge gets, I believe, even under the current law, if a judge has two evaluations that are unsatisfactory, then it can become public. Whether it becomes public automatically or not, to be honest with you, I'm not sure, but I think it might be.
Follow up?
Thank you. If I appear in front of a judge as an attorney and I then submit an evaluation and I do it professionally and it has nothing to do with the decision, it's based on demeanor and those kinds of things, both currently and under this bill, can I submit it confidentially, or would my name necessarily be associated with my submission?
Now, under both the current system and this, that you'll notice there is language in this bill that says before the information is published or released either to the public or the judge, the submissions are anonymous. I think the term it uses are anonymized, so that if you submitted an evaluation of Judge Jones, your name would not be disclosed to Judge Jones. Your comments would, but the name would not.
Any other questions? Oh, seeing none. Thank you very much.
Thank you.
Representative Lori Corzine?
Thank you, Mr. Chair and members of the committee. My name is Lori Corzin, and I represent Coas County District 7, which includes Berlin, Whitefield, Jefferson, Kilkenny, and Twin Mountain. I am here today in strong support of HB 1130 because public trust in our judicial system is at an all-time low. And tragedies like the death of Marisol Fuentes shows us exactly why. On April 25th of last year, Marisol walked into the Berlin Police Department and reported that her estranged husband had kidnapped her, sexually assaulted her, and stolen over $8,000 from her. She was terrified. She told police she was petrified of what would happen to her. She did everything right. She reported, she trusted the system, and she sought help. The next day, her abuser was arrested and charged with felonious sexual assault, kidnapping, and theft. All three are felonies. Our police prosecutor fought for preventative detention, citing the violence, the control, and the clear danger that he posed. But a magistrate looked at that evidence, which was a 4-page handwritten account of the brutal violence, a victim in fear, and a man who had stolen thousands to control her, and decided that $5,000 was sufficient. $5,000 was less than the amount that he stole from her. In essence, this magistrate forced Marisol to pay for her murderer's bail. 2 days later, a circuit court judge had the opportunity to correct that decision. She declined. The $5,000 bail stood. So he walked free. And while he was out on bail, a man that should have been behind bars for 3 separate felony charges, on July 1st, just 5 days before he murdered Marisol, a minor in Berlin came forward and filed a stalking order against the same man. He had been sexually assaulting her. She told the court he had weapons. That information never triggered a bail review. No one acted. The courts had yet another chance to protect the community, and they just let it pass. 5 days later, on July 6th, he walked into Marisol's workplace with a shotgun and murdered her in cold blood. This was not justice. This was judicial negligence. HB 1130 does not seek revenge. It does seek accountability. It establishes a comprehensive system of judicial performance evaluations, including in-court observations, statistical analysis, and public questionnaires for judges who fail to meet and mandatory interventions for judges who fail to meet those standards. It brings transparency back to a system that has operated behind closed doors for far too long. We should hold every public servant accountable, especially the ones whose decisions can mean life or death. This bill could solve that. Marisol Fuentes trusted our courts to protect her. A minor trusted the system to protect her. They were both failed. We owe it to them and to every victim who comes after to build a judiciary worthy of trust. I urge this committee to pass HB 1130. Let it be a promise that judicial authority will never again outweigh human life. Thank you.
Thank you. Are there any questions? Nope, seeing none. Thank you very much. Lynn Cholette?
Good morning, Mr. Chairman, members of the committee. My name is Lynn Cholette, and I'm the Executive Director of the New Hampshire Coalition Against Domestic and Sexual Violence, and we are here in strong support of House Bill 1130. I have spent the past 30 years working in the field of crime victim services, and in that capacity, I have seen the positive impact that effective judges can have in the courtroom, as well as the traumatizing harm that ineffective judges can have. House Bill 1130 recognizes the importance of a judicial system that is transparent, that ensures accountability, and upholds public trust, as you've heard from other witnesses. Judicial performance evaluations are well-established methods of assessing potential training or educational needs of judges. 12 other states have them embedded in their statutes, and many other states do this through their bar associations. Judicial process or judicial performance evaluations don't look at case outcomes. That's really important, but rather they're focused on the impartiality of the judge, the clarity of their communications, judicial temperament, some administrative capacity, all things that could be addressed with training or mentorship or the right tools. This bill reflects best practices that have been highlighted by a recent report, a 2025 report by the Advancement of the American Legal System, which is a leading organization addressing judicial performance and accountability. I'm happy to leave a copy of their 2025 report for you. Based on this report, this bill adds a requirement of the collection of specific data, objective information like how long does it take a judge to rule on a particular motion, as well as Justice Lynn referenced courtroom observations by neutral parties. Collecting more data will help provide a more comprehensive and accurate portrayal of a judge's performance while mitigating the biases of the folks who are reporting. Considering the vast number of people who appear in front of judges in New Hampshire without being represented by attorneys, in the field of domestic violence, only 12% of victims ever have an attorney representing them in a protective order case. This is vital. We recognize that most judges do an excellent job, carrying a heavy caseload with stretched resources. We also, unfortunately, frequently receive concerning reports from victims, prosecutors, private lawyers, and other stakeholders about a much smaller group of judges who routinely ignore statewide protocols or treat victims and even lawyers in manners that are inconsistent with what we would expect of judges. Crime victims, like all citizens in New Hampshire, deserve a justice system that is informed, responsive, and prepared to act with the seriousness that domestic violence and other crimes demand. We should readily adopt any strategies that will address and improve judicial accountability. So I encourage you and request that you consider adopting House Bill 1130 to help strengthen the evaluation process in New Hampshire today. And I've got copies of my testimony and the report to leave with you.
Thank you. Representative Page.
Hi, thanks for the question. Thanks for taking my question.
Yes.
It sounds like from Chief Justice or Chair Lynn's testimony, there was some questions, thoughtful questions from Judge Pendleton. I haven't seen those, but we will. I'm guessing they might have to do with publication, and I'm wondering, given your support of the bill, as it stands now, whether you view those as sort of room to make corrections or amendments, I should say, to what
We would
have here.
Thank you for the question, Representative. We would certainly be happy to work with stakeholders if there are proposed tweaks or amendments to the process moving forward. I do think one of the issues that we see, we recognize that current evaluations are available for people to fill out. They are on the court system's website. However, they're available for pretty limited amounts of time. And most crime victims who aren't living in the world of courts and having lawyers may not even know or come across these. Attorneys who are involved in the Bar Association have a lot more information. So access to the process and some publication of anonymized data would be very important to us as a community.
Thank you. Representative Birch.
Thank you, and appreciate your testimony. But I want to understand it better. We have a process already, and that process describes the evaluation criteria, which you say should be in an evaluation, having to do with management skills, legal knowledge, bias, objectivity, and all of that. That's already in the law. That's not the subject of this bill. My question to you, if I understand your testimony, is if this bill, what it does is allow all comments about a judge, whether it has to do with these issues or a group of 50 people who write in, this judge hates women, this judge hates men, this judge appears drunk on the bench, whatever it may be, you're supporting the publication anonymously of those complaints individually against judges.
We would support the publication of individual comments, yes. We also realize that it's important that those be anonymized to reduce any disinclination that someone might have to report. I think one of the challenges with a list of specific criteria that people can report on is it might exclude others. One of the examples that we experience as a crime victim community is we have a statewide protocol on domestic violence. Unfortunately, while many judges follow it well, there are some judges who do not implement it. And we would want there to be a place for that to come to light.
Thank you.
Any other questions? Oh, seeing none, thank you.
Thank you very much.
Lauren Warner?
Good morning, honorable members of the committee. My name is Lauren Warner, and I serve as the Deputy General Counsel for the Judicial Branch. I do have copies which I can pass out of the testimony Representative Lynn referred to from Judge Pennington, as well as 2 other judges. I just want to note that this written testimony isn't on behalf of the Judicial Branch. It's in each judge's individual capacity, but was sent to us, and I have copies which I will give to you all. It is for this bill as well as 1501 and 1509. In regards to the current bill performance evaluations, Representative Lynn noted 2 comments which have come forward from judges. Just we wanted to note in terms of publicizing comments automatically through this bill, which it proposes, there has been concerns regarding just in general, potentially public comments which do not relate to the judge's performance and not to the merits of the case that can be automatically publicized through this process. Certainly, judges view this evaluation process as a helpful tool to improve their performance, but automatically making public comment published might incentivize others to essentially use this forum to criticize judges' potential outcome of a case and not related to their actual performance evaluation and their applying the Judicial Code of Conduct. As noted, I think there's been previous testimony regarding potentially using this forum for a judge which is not necessarily complying with certain protocols. The Judicial Conduct Committee is certainly an appropriate avenue where complaints regarding judges' performance and inability to or failure to comply with certain protocols would be the appropriate avenue to bring those as opposed to waiting for a performance evaluation. Just wanted to note that. As well as noted by Representative Birch, you are correct. The American Bar Association guidelines essentially recommend that judicial evaluation public comment not be posted publicly. I could even note guideline 3.2 and 3.3. 3.2, when judicial evaluations are used only for judicial self-improvement, individual results should be provided only to the judge evaluated and the presiding or supervisory judge responsible for the performance of that judge. As well as guideline 3.3, when judicial evaluations are used to improve the quality of judiciary as a whole, results should not identify or give comparative ranking as to individual judges. Essentially, the goal of this bill is to improve judicial performance, and we want to ensure that the performance evaluations meet this goal. Noting the statistical evaluation aspect of this bill, just wanted to note in particular for circuit court judges have an extremely limited control over their dockets. Case processing time is primarily driven by clerks' management of the schedule and allocation of judicial time in each court. For example, a 2-day divorce trial in Berlin may be scheduled within 4 months, whereas an identical matter in Brentwood might not be scheduled for over a year. This is completely out of the judge's control. Because judges have no authority over these scheduling differences, evaluating them on this merit may foster tensions between judges and clerks and can negatively impact court operations. Certainly, I would note in particular, circuit court resources vary and can be less than other, perhaps the Superior Court or Supreme Court. So potentially looking more into what type of statistical analysis might be used would be more beneficial in this matter. And that is it. I welcome any questions the committee might have.
You have some written testimony you're going to send around?
Yes, it's from 3 judges, which it is not on behalf of the judicial branch. I just want to note it's in their individual capacity as a judge, but I will pass that out.
Okay. Any questions?
What about your testimony?
I don't have written testimony. I just I can certainly provide and draft up written testimony for you. I just had notes that I was going over today, but I am more than happy to put together written testimony and send it to the committee.
Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. Is it the judicial branch's view that this bill would cover bail commissioners?
I apologize. As a judicial officer, I do not believe so, but I would have to get back to you on that.
Would you do that?
Yes, certainly.
Thank you.
Any other questions? Oh, seeing none, thank you very much.
Thank you.
And you can, if you want to turn in anything you have, they'll send it around. Appreciate it. Thank you. Robert Tangway?
Good morning, Honorable Committee, Chairman Lynn, Rep. Ball, and Rep. Kutab, and anybody else that I've forgotten that I've met before. My name's Robert Tangway. I'm the author of New Hampshire Oliver Twist. There's this bill I do support, but we have to look at this wide. There's a couple issues I can go into specifics with the bill that you guys should change, but there is a contention that pro se litigants don't know what they're talking about. Welcome to Revolution Day. All the bills you're going to hear today are about reforming our judiciary. Our judiciary is far more powerful. This is one of the most powerful committees in the House. And our judiciary says that they're the shield, but they use that shield as a weapon. We have a state of political protection and persecution and prosecution. They can choose, a judge can choose any outcome they want. What's concerning is actually Pendleton. I don't think he's a good judge. He put Justin Nato in jail for not paying, and he's currently in jail.
Excuse me, we're not going to disparage other members from other groups, judges or whatnot, so.
Okay.
We appreciate your opinion, but.
Well, that's just a fact, but I'll respect that because that's not what I want to get into. So the previous person just mentioned the family court docket's extremely limited. And that's where all the problems are coming from, because the family, when you go to family court, it's pretty much a private hearing where nobody's in there except for the parties, maybe the mother and such. I've been able to bring some other people. But when you go into the circuit court, criminal, superior court, there's prosecutors there. The judges act very well because other people are looking. But when you're in the family court, they treat you like crap. I have videos of it. Article 8 requires the government to be responsive and accountable, and that's what this does. So I like this bill. There's a couple things that I don't. So really what I want to say is we need to fund our courts better. We need more court time. The problems that you're having is because the judges aren't following the rules. They're not following the domestic violence protocol for victims against men. 86.4% of all child support cases are awarded where the man has to pay. I will send you the opportunity notice from the DOJ, this building right here, where they, in 6 separate paragraphs, train police, judges, and prosecutors. So the judges would be the family court judges that they handle DVs to only protect women using federal grant money. And then you have the statistical analysis of 86.4%. Men are getting treated poorly. And the women who are getting treated poorly, because it does happen, are usually less politically connected or do not act as a woman should, which is a victim. We have a victim mentality. That's what we need to shake. So the statistical analysis of case processing time, we need more time. They need less, but that's coming from Title IV-D grant money and the expedited child support process and contract, which the state has signed with the Supreme Court and the administrative courts to expedite. They get reduced funding, and if they don't have 75% of cases within 6 months or 90% of cases within a year. So she just said, oh, some people don't schedule out for a year. No, they gerrymander all that stuff. I don't want to get into the details of my case because it doesn't matter. What matters is what we're doing is holding judges accountable, which they are required by the Constitution. And we have a system of people who all know each other and are all working together to protect each other. And it all comes appointed from outside funding sources, the governors, the senators. They get more money from outside sources than they do inside. People are buying and selling our state. So statistical analysis of case processing time, I think that that's something that you guys should look at. Again, you guys have a job. You're going to exec this out. It's an important bill, and I appreciate it. Now, I also, on page 2, I think it's line 12, judicial officer fails to achieve an overall satisfactory judicial evaluation during 2 consecutive evaluations. Any. Nip it at the bud. The biggest thing that I had, I'm suing a lawyer now. The biggest thing that I had was, how do you stop a judge from lying in real time? And the only way you can do that is sue them in federal court, which people are doing in New Hampshire. But then that freezes your case, and your case is frozen. So it's a really difficult thing. So we need to nip this in the bud. That's all I have for this bill. Thank you for hearing me out. If you have any questions, I'm going to be speaking all day today. So I'm very knowledgeable. I know the laws. I know the realities.
Thank you. Any questions? Okay. Seeing none, thank you very much.
Thank you so much.
I believe that's the last card I have. Is there anyone here that wants to speak on this bill that hasn't turned a pink card in? Seeing none, I'm going to close the hearing on House Bill 1130, and I'm going to turn it back over to Chairman Lynn.
Thank you. You're welcome. Thank you. All right, so I'm now going to open the hearing on HB 1501, and do you have a pink card? Oh, thank you. Thank you. And I will recognize Representative DeRoy.
Good morning, honorable members of the committee, chair, and fellow citizens in the room. My name is Susan DeRoy, and I am a representative of New Durham and Middleton. As a representative who has many constituents who have been affected by the decisions within our courts, I come before you today to urge meaningful reform in the New Hampshire judicial system. The problems aren't isolated to one division. Don't be fooled. They affect access to justice, public safety, constitutional rights, and trust in the rule of law across the board. I am not here to undermine the judiciary. Judges and magistrates perform vital work and honest good faith rulings and must be protected to preserve independence. However, absolute judicial immunity has evolved into a overbroad shield that insulates even serious errors, negligence, bad faith, or right violations from civil or criminal responsibility. When combined with other systemic issues, ineffective oversight, questionable handling of high-profile cases, a lack of transparency, this doctrine allows problems to persist without remedy, eroding confidence in the entire court and law enforcement system. New Hampshire courts face widespread documented criticisms. We're hearing them now. Arbitrary rulings, apparent biases, ignored evidence, procedural lapses, and decisions that sometimes prioritize convenience over institutional protection, over individuals' rights and public safety. The Judicial Conduct Committee, primary mechanism for addressing the judicial misconduct, receives complaints but dismisses a high percentage early, often deeming them outside scope, appellate nature,
rather than ethical violations lacking sufficient evidence or jurisdictional. Annual reports show dozens of matters reviewed each year across divisions, yet few result in sanctions. Many who file reports report the progress is opaque, slow, or ineffective, with confidentiality rules limiting public scrutiny. This leaves citizens feeling that complaints are not truly addressed or received in a meaningful manner. Tragic examples illustrate the human cost of unchecked decisions. I don't want to go through the Marisol case again because it's already been spoken to, but that's a direct effect of this. So I'm going to move into the Supreme Court part. At the Supreme Court level, controversies compound perceptions of a protected or uneven system. Felony-related charges against Court Justice Marconi, who returned to the bench after a plea amid questions of influence, raised concerns of favoritism by her fellow judges, who are also key witnesses to her alleged or pay-to-play dynamics. In Richard versus Governor, Sununu, Daniel Richard challenged the election laws and practices alleging violations of voting rights, due process, and equal protection. The Supreme Court granted standing for key claims, recognizing concrete injury, yet after supplemental briefing proceedings that span from 2022 to 2026, the case was dismissed. Critics view the handling as prolonged and ultimately dismissive despite the initial standing win, contributing to questions about timeliness, consistency, impartiality, and addressing fundamental constitutional challenges. Family court. Matters that exemplify these broader issues in high-stake personal contexts, arbitrary custody and support rulings, apparent biases, often against fathers or domestic violence victims, reliance on unsubstantiated claims, and decisions that can permanently damage families and lead to unintended, devastating criminal consequences. National statistics show imbalances, with mothers as the custodial parents in 80% of the cases, and fathers averaging 35 parental time, even in contested matters. Legislative hearings in 2023 and advocacy groups have highlighted these patterns, yet recourse remains limited. Most tellingly was Supreme Court Justice Gordon MacDonald himself during a State Bar Association program for legislators that said, "Our court is broken." A candid acknowledgement of the judiciary's leader of deep inefficiencies, access barriers, and structural flaws. The Administrative Office of Courts and the Disciplinary Office are tied to the Supreme Court in such a way that it further creates a closed circuit of protection for the judiciary and its favored attorneys while discussing citizen rights to justice and accountability. Absolute judicial immunity bars civil suits and criminal inquiry, even for malicious, corrupt, gross negligence, and clearly rights-violating acts within the jurisdiction. The insulation is dangerous across the system, whether it's in family division, severing parent-child bonds, bail decisions endangering lives, criminal trials and sentencing, or election cases implicating democratic integrity. Victims of due process or equal protections have virtually no civil remedy. I urge this committee to support targeted reform, shift towards qualified immunity for judges and magistrates, as it applies to most government officials, requiring proof of a violation of clearly established rights or create exceptions for proven corruption, bad faith, or clear safety right oversights. The modest approach, drawing from a scholarly proposal like Bailey Barnes' analysis in the Tennessee Law Review, tying immunity to meaningful appellate review, could deter egregious conduct while preserving protection for good faith errors through the high evidentiary thresholds and safeguards against frivolous claims. New Hampshire can lead the way. We've done it a lot of times. We are live free or die when judicial officers operate with near total insulation amid evidence of systematic failures, fatal lapses, questionable case handling, secrecy, and the Chief Justice's own admission that the system is broken, we fall short of that ideal. Limiting immunity is not an attack on the courts. It is necessary to restore accountability, rebuild public trust, and ensure justice serves all citizens, not just in robes. Thank you.
Thank you. Questions for this witness? Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. Do you have any instances where judges have committed acts that weren't criminal or civil liability?
That weren't criminal or civil?
Yes.
Not in my possession right now, no. I don't. But I'm sure that some of our people that are back here that are going to be talking probably have. Most of the people that I've been dealing with are people or family court system that I've gone to the court hearings, I've been listening and seeing what's been going on, and it's troublesome. Paperwork that goes to another state where my constituent doesn't live, almost being arrested, having their child be taken away from them for 20 years when they're a good citizen. These are the types of things that we're dealing with right now.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Lauren Warner, please.
Hello, my name is Lauren Warner. Good morning, honorable members of the committee. I serve as Deputy General Counsel of the Judicial Branch. As noted previously, the 3 different written testimonies that were handed out will also reference this bill as well as 1509 if you would like to see some written testimony provided in their individual capacity as a judge. But as to the judicial branch as a whole, the judicial branch is not taking a position on this bill as historically leave all matters of policy up to the legislature, but we would like to note just a few things in regards to this bill. First, it was previously testified to regarding the Chief Justice McDonald's comment as to the system is broken. That was in reference, and I spoke to Chief Justice McDonald this morning, in access to justice. Just the fact that there are so many individuals coming to the courts that don't have access to an attorney and are self-representing, and so this access to justice is a concern of the judicial branch, not as to the judicial branch as a whole is broken or the court system itself. In terms of this bill specifically, it is noting intentional torts, criminal conduct, and corrupt actions. I would note already judges are not immune for intentional torts, criminal conduct, or corrupt actions as it is. They would not be provided judicial immunity if they were found guilty of criminal conduct, intentional torts, or corrupt actions. I also just noting in general, just malicious acts. It's slightly overly broad. We don't know exactly what that encompasses. Any malicious act or an allegation of a judge performing outside of their duties or violating the judicial code of conduct, which covers a great deal of what this bill involves, would be going to the Judicial Conduct Committee to review, which they have the ability to take disciplinary action, remove a judge. There are also, through the judicial branch, employment actions that can be taken. So the disciplinary process is administered by the Judicial Conduct Committee, which not only includes consisting of 11 members of judges, lawyers, as well as members of the public. In general, I think that is it. I will leave it for the committee to review the written testimony submitted by the judges to get their opinion of the bill, but I welcome any questions you might have.
Questions for this witness? Yes, Representative Birch.
Thank you, and thank you for your testimony again. Would it be fair to say that the basic purpose of judicial immunity is not to protect individual judges, but to preserve the public's interest in an independent and impartial judiciary as ruled twice by the three times by the U.S. Supreme Court and twice by our own New Hampshire Supreme Court?
Yes, I would agree with you, Representative.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Representative Ellen Reed, please.
Thank you, Mr. Chair and members of the Judiciary. It's been a while since I've been before you, so I appreciate it. For the record, my name is Ellen Reed. I represent Rockingham 10, which is Newmarket and Newfields, and I am here to testify in favor of the concept of this bill generally, simply because I believe no one should be above the law. I understand that's not what's currently happening in policy, but there may be reason to suspect that it might be happening de facto. I don't believe anyone should be above the law, and I am, just as me personally, being known how my policy is aligned as a leftist principle. It's always been a liberal principle, a leftist principle, that no one should be above the law. That includes presidents, it includes police officers, it includes departments of the executive branch, it includes us, the legislative branch, and it includes organizations funded by taxpayer money. And that is why I'm in favor of this bill in concept. I cannot weigh in on specific issues that have been brought up. I don't even necessarily think I necessarily agree with any of the, or some of those issues, but what I will say is that you don't have to agree on what happened, if some malfeasance had happened in this case or that case, to support this. Because, first of all, I've seen enough, just even in the news, to warrant a concern that something might be happening in a de facto way where certain people are treated with more preferential treatment than other people. And even if this is not happening, this is a very measured prophylactic. It is a precautionary action to do the basic function of government, which is hold government accountable to the people, right? We have to be accountable to the people. We have to be transparent. We cannot be above the law ourselves. I will note, just kind of as a point of interest, that the fiscal note by the judicial branch says indeterminable increase, $0 to $250,000, and I understand that this is, meant to be a broad ballpark, but it seems that the judicial branch may be kind of low-key admitting here that there may be up to $250,000 worth of issues that this would impact. So places where perhaps the judicial branch or members of the judicial branch acted in such ways that if this were to pass, then they would be held accountable. This is not a blanket prohibition on any kind of immunity. I think it's very measured. I think it's very moderate. It's saying that there can be immunity if it's directly related to carrying out those duties, which is consistent with what Representative Birch said. But it's saying that no one's above the law, which is something that we should already know, and it should already be in place. And yet there's reason to believe that that's not always happening. I taught American government at the college level for several years. And one of the things I taught was that one of the founding principles is written about by the founders in the Federalist Essays is that one of the principles of a constitutional constitutional representative democracy, which is also called a republic, is that no one should be above the law. These were people who were coming out of a monarchy where there were definitely people who did not have to obey the law. So this principle has never been practiced perfectly in this country. We have always, like pretty much every society, have had classes of people that receive preferential treatment by the system, that are considered, if not explicitly laid out in the system, in practice, better than certain other classes of people. But I believe in MLK's quote that the arc of the moral universe is long but bends towards justice. And I think every measure where we can explicitly put into law that no one is above the law is a step in the right direction. So whether or not it's already happening doesn't matter. This is a measured prophylactic action that can be taken to make sure that we have some tool at our disposal to prevent it from happening in the future. And for that reason, I am supportive of the concept. If you need to amend it, so be it.
Questions for this witness? Seeing none, thank you very much. Next, Jason Gerhard, please.
Good morning, members of the committee. Jason Gerhard, Northfield, New Hampshire. I'm in support of this bill for the simple fact that, as many have already said, that no one should be above the law. Because even though certain situations and cases have come up with judicial misconduct or whatever you want to term it, just improprieties, it seems that when punishment is doled out, it's kind of a slap on the wrist and it's more theater than substance. And I think that's problematic for support, or let's say trust in government in general. I do think we're at a record low for trust in government, especially among the younger demographic in this country. There's been a lot of things going on, a lot of things that our federal Department of Justice has dropped the ball on and continues to. And I just wanted to bring up, well, first off, let me bring up the letter and email that Claire Best sent the committee. I think this is very detailed. I'm not going to read it, but she goes through specific cases of judges and the punishments that they were doled out with links. It's very informative. And just going off the first one, Judge Julie Introcaso, I find this especially problematic because this is from Wikipedia. She was arrested on February 11, 2021. 2 felony charges of falsifying physical evidence.
What are we're not going to get into sort of, you know.
She pled guilty though, sir.
Yeah, no, I understand that, but we're not going to get into the details of any particular cases. And why is that relevant?
It's relevant in that the charges initially charged versus what was what was later accepted, the plea. That's what I'm trying to establish. All right, I'll just mention the level of charge, I guess. Does it make difference?
Okay, go ahead.
You know, I'm not trying, yeah, I mean, she's already out of the whole situation, the club, as it were. So we have 2 felony charges, 2 misdemeanor charges, and another misdemeanor charge. And then the plea that was accepted became some misdemeanors, and it ended up being a suspended 12-month jail sentence and 100 hours of community service.
I guess the thing I'm having some trouble. How does this bill deal with that issue? If you think that the decision, you know, in that case was inappropriate, how does this bill change that?
Well, in the fact that this bill is limiting judicial immunity, which I think is kind of what happened here. It was a pseudo judicial immunity. That's what I'm trying to get at. I'm saying is that we have certain classes of people who are held to different standards in the judicial system.
Okay.
So, okay. And then just to contrast with a high-profile case of perjury was Sheriff Mark Brave. And he ended up doing 3.5 to 7 years in prison. That was his sentence. Now, he also had theft involved, I understand. But I don't think there's an even doling out of justice when we have people within certain branches of government coming before the judiciary. And that's what I'm concerned about. Because Article 14, legal remedies to be free, complete, and prompt, I think it can be pretty well documented that we're not having that happen now on a wide. I've been hearing a lot of situations with family court cases, especially, but it seems to be kind of widespread. And that's what I'm concerned about, and that's what I wanted to bring up. And in general, last thing I'll say is, this is not this committee only, but in general, I'm concerned that the standing committees in the House are not actually conducting any investigations of themselves. So real quick, Criminal Justice Committee, we had the first, the second, and I was told the third, but I can't confirm that, in charge of the Department of Corrections stepped down last year. And we've had no investigations from the legislative branch. To me, that just seemed absurd. So we've been kind of given the, just trust me, bro. But I think most people in the state are saying, we don't trust you. And I think that's what this is important about. And that's why I'm in support of this bill.
All right. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Joseph Nugent, please.
Thank you, Mr. Chairman. Joseph Nugent of Jefferson, New Hampshire. Thank you for taking my time to make this testimony, members of the committee. I'm here to testify in favor of this bill, HB 1501. I think the reason that this has become necessary is that there have been so many other remedies to address this issue in the state and in this House that haven't come about and haven't been exercised, that people are now moving towards what might be perceived as something extreme, getting rid of judicial immunity. I think this is happening a lot. We've heard a lot today about people in family court, and I think that if it were to be put into some other bills, or perhaps in this one, that if there were disclosure to families that people going before the family court were actually before an administrative court, I think that that would help stop a lot of the complaints that you as representatives hear. People are not being informed that they have no rights before these statutory courts. And I think as Americans, we go before judges and courts and we think that we have rights. However, the statutes in our state have been devolved to the place where these rights are not being accepted. So I think if this bill, for example, or any bill, law that would state that it shouldn't be repugnant to the Constitution, I think that there would be less pushback and less need for us to go into these extreme areas of judicial immunity. But I think that that's where we're at. I think this bill is just representative of where we are. My friend Marisol was shot in Berlin this year. It was a tragic failure of systemic levels, and I know people because I'm from Coos County. It's a small county. There's been a lot of conversation about what went on there, and including with her very best friends. Marisol was a light to the entire area of Berlin, New Hampshire, but there was a culture where the judicial officers did not want to change the order, the previous bail order. I know you don't want us to mention names of the magistrate judge who was relieved from duty, but 2 district court judges upheld that duty. And I'm not saying that we should lose their immunity because of these really bad decisions, but I think we should address the culture in the judiciary that people do not want to go against another judge. It's hard to not name names. One district court judge didn't want to change the magistrate court's bail hearing, and Marisol was killed over this. Another judge who's been being complained about for 8.5 years also upheld that bail order and didn't even have Marisol at her own probable cause hearing where this issue could have been addressed. So I believe that this bill would allow people to create a paper trail where these tragic mistakes could be looked at more, because they would be able to take cases. And I just don't believe from personal experience that the Judicial Conduct Committee is doing anything. I mean, the nickname from the people is that it's a judicial cover-up committee. And, if we're here to represent the people, we need to address these issues. We have lots of ways to do this. This is a great state, New Hampshire. I believe that Article 4 and Article 5, Part 2, form of government, would allow this, and it would be good steps that if they were exercised, we wouldn't be at this place. I just want to finish up by saying that I think in line, the part of the bill that says 490 L2C, I would love to see words added to the effect of constitutional protections. I just don't believe that there's enough attention these days to respecting our constitutional protections, and there's not enough accountability of these judges that's now requiring this type of bill to come before you. Thank you for your time.
Thank you, sir. Questions for this witness? Seeing none, thank you. Next, Robert Tangway. I'm sorry, Robert Tangway.
Thank you. Joke, maybe you might want to call me a dick. I don't know. Robert Tangway. I support this bill, limiting judicial immunity. When you get to the U.S. Supreme Court level, Just to let you guys all know, I'm supposed to wear glasses, I don't wear glasses, so you guys are a blur. I'm speaking from my heart. I can see a little bit. But anyways, Supreme Court, US Supreme Court is kind of stagnant on this. There's 1983 lawsuits, right, that you can, but that's only when declaratory relief can or has been violated or cannot be found, which is super vague, right? So that's a 1983 lawsuit. The civil way, what's going on in in Minnesota is horrible, no matter what side you are. I don't protest. It's to file lawsuits. That's what the rich people do. That's what the president does. He's suing Scanlon, not to without the merits, right? That's what you do. The courts are civil to relieve the pressure. This place is civil to relieve the pressure so that we're all peaceful. I reported judicial misconduct to the Supreme Court. They wrote denied. Rule 38, 2.15, clerk, which I reported to, and the lower courts in writing and on the phone, by not taking any action on a reported judicial misconduct, in itself is an act of judicial misconduct. That's our entire Supreme Court currently. We have preferred litigants. Preferred litigants, that's what we have. Outcomes already decided. The only protection from that is a jury. This will allow us to get to a jury. Hans Marconi, in one of her last opinions, she led the court, New Hampshire Supreme Court, saying that this court, Supreme Court, is often skeptical of sovereign immunity, especially when there's a law there. I think that has to go into play with her prosecution. So this is a law that says very clear that you can sue a judge. And you can't use judicial immunity in the state of New Hampshire. It'll get heard out. They can settle, or it can go to a jury and the jury decides. And then they can settle anyways. And then the Supreme Court can overturn it and do all these things. Then you should be able to sue the Supreme Court. You should be able to sue anybody you want, civil procedure. Article 8 already allows this. It already allows it. So this is just a law that allows you to do it. And so this is 14. So the supreme law of the land in Article 14 is Article 8, the Constitution. Article 20 says a solemn right to a jury trial for any matter over $1,500. Judges caused me more than $1,500 in damage, for sure. So I will be suing them. Now it'll probably get dismissed and denied and and then you can go. But keep going, and then you'll get justice. Any questions? I'd be happy to answer, but that's, restatement of torts. So you guys need to look. So most of the torts in New Hampshire are common law. They're not specifically described. So then you have to go to the restatement of torts to find the damages and all that stuff, or causes of action. So when you guys are looking to put to bills, you might want to consider putting in like some teeth. It says civil tort proceedings, but you have to have a tort. And I haven't found a tort of fraud. So I'm certain for malicious prosecution and abusive process. That's where it's at right now in the Superior Court. Restatement of torts. We need more statutes.
Thank you, sir. Questions for this witness? Seeing none, thank you. I'm going to take a stab at this Robert Lundenhogue. No, I'm sorry.
I'm Robert LaMontagne.
LaMontagne, I'm sorry. Thank you, Mr. LaMontagne. Please have a seat.
Thank you. So, first of all, I want to say.
You know what, can I just ask, pull the microphone over? Thank you.
All right, how do I sound? Okay?
Great.
All right, so when I came in here, I checked off the wrong box. I'm pro for this, so I apologize for that. I didn't have on my glasses.
Okay, that's all right.
All right,
We'll
so-
change it to indicate that you support the bill.
Yes, I do.
All right.
Okay, so, members of the committee, House Bill 1501 goes to the heart of why I am still fighting nearly 40 years after my conviction. That's 4-0, 4-0, okay? In 1990, I was convicted in Cheshire County and spent nearly almost a decade in prison on charges I have denied. My name, my work, and my relationships were destroyed. 3 generations of my family, myself and my daughter, and now my grandchildren have been living under the weight of the conviction and was secured with intent evidence and withheld truth, if that came out right. The lead detective and the star witness against me, former Keene officer James F. McLaughlin, who I've been able to expose, had documented history of lying and evidence problems before my case and was on the New Hampshire exculpatory evidence schedule, which there wasn't one back then, but it's got a title name now. It's called the Brady v. Maryland Law. At the time of my trial, the impeachment material was never disclosed to my lawyer or to me, despite the Constitution's clear requirement that such exculpatory and credibility evidence to be turned over to the defense, which it did not happen. The human cost.
Sir, I guess you need to kind of direct your testimony to this bill. And so
Right, and this is the only way that I know how to do, because I'm speaking for myself. Okay. I know a lot of other people, hundreds of people have been affected by what I've gone through. Right. And it's not just men, it's both women.
I guess my question though is this, I understand your view on what happened in your case. I understand what you're saying.
Right.
I guess what I think would be helpful to the committee is knowing how you think this bill, if it were to become law, would be would prevent something like what you say happened to you from happening again.
Right. Well, I mean, I think the thing that's important is that when you go to a court or a trial, it's no different than a contract. Okay? My attorney signs it, I sign it, and then the prosecuting attorney and the court sign it. It's a deal. Okay? And the county attorney never turned over exculpatory evidence in my trial that would have proved my innocence. Okay? And I've been fighting and fighting and fighting this. You know, I'm in the courts right now fighting this. The Innocence Project is following my case. Okay? I have an attorney now that's taking my case pro bono. Okay? I'm 62 years old. And I don't want to see anybody else go through with what I went through. All I want to do is I want to clear my name so I can, when I leave this world, I can leave with some dignity. I don't think that that's too much to ask. You know, if you want me to play by the same rules while we're in court, I expect that the county attorney or the district attorney to do the same damn thing. You know, because if nothing is done about this, then you all give the eternal right to have that same thing done to any one of you. I'm sorry, I'm just...
No. That's anything else you want to tell us?
No, I think I've yelled enough.
All right. Questions for this witness?
Yes.
Oh, yes, Representative McFarland.
Thank you, Mr. Chairman. My question for the witness is, you know, we've heard the testimony that I think you've already listened to as well around this bill. And in your opinion, not what was done wrong to you by the county attorney, but in your opinion, and using your case as an exemplar, what do you think where do you think the judge in your case acted wrongfully in a way that this bill would help correct?
Okay, so during a testimony evidence, a videotaped deposition done by my children, after the videotape deposition was finished, okay, the judge that sat on that bench said a person would have to have a sick mind to do something like what I did. according being accused, and there was no stenographer in there when these videotape depositions were going on.
Thank you.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Anyone, anyone else here to testify on 1501? All right, seeing none, I'm going to close the hearing on House Bill 1501, and I'm going to open the hearing on House Bill 1509, and is Representative Trottier here? Anyone here to testify on House Bill 1509? Yeah, would you, yeah, good. Hang on one second. Thank you. The chair, with thanks, the chair recognizes Representative Kutab to introduce the bill.
Thank you. I'm Representative Caitlin Kutab, and in the absence of the sponsor, I am here to introduce House Bill 1509 relative to judicial immunity and permitting civil actions against judicial officers for certain criminal bail decisions. And I will not be taking any questions. Thank you.
Thank you, Representative Kutab. All right, next I'm going to recognize Robert Tangway, please.
Good almost afternoon. Robert Tangway here. I support this bill. I haven't really fully understood it, but the reason that I do like it is that it provides a clear legislated opportunity to go forward with a claim. That claim might not go through, but it can't be barred because there's no cause of action. And then where there's disputed facts, the plaintiff and defendant will have to duke it out in mediation or whatnot. I don't have anything to say specifically about changing it because this is not one of the most important. Oh, wait, I apologize. I was looking at the wrong one. Okay, now I know exactly because I did read this. I'm a little wishy-washy on this bill. This bill is for relative to the appeals for convictions in circuit court, or is that what we're talking about here?
1509, House Bill 1509.
FN. I was correct. Okay, so to go back to that, anything that allows an action for a lawsuit and stops it from being disbarred is very important. So I do support this. I don't have any recommendations to change it because I'm not as fluent with this particular bill. So I'll just reserve my time for other people or have future bills, unless you have questions.
Right. Thank you. Questions for this witness? Seeing none, thank you very much, sir. Next, Lauren Warner from the Judicial Branch.
Good morning again, honorable members of the committee. My name is Lauren Warner, and I serve as Deputy General Counsel of the Judicial Branch. Just wanted to note briefly on 1509 regarding judicial immunity, or essentially removing judicial immunity for, on certain bail decisions if the individual who is granted bail commits a criminal offense after being released on bail. Currently, Chapter 597 prescribes when a judge may issue bail and provides certain confines as to when bail may be awarded and when it may not. If judges are subjected to civil liability regarding bail decisions, this may lead to essentially judges refusing to potentially sit on bail hearings or an unwillingness to do so as potentially being subjected to civil liability for individuals' criminal conduct after the fact that is obviously unbeknownst to the judge whether or not they would do so at that time, as well as it potentially could incentivize an unintended consequences of this bill is a potential incentivize to essentially not grant bail in certain situations that might otherwise be warranted under 597. A judge shouldn't consider in determining whether or not bail should be granted, whether or not a lawsuit would result against them as a result of this decision. This would violate the Judicial Code of Conduct, as well as violate 597, and would put judges in a very uncomfortable situation to potentially have to consider other ramifications outside of the confines of this 597. I'll welcome any questions the committee might have.
Thank you. Questions for this witness? Seeing none, thank you very much. Oh, whoop, I'm sorry, Representative McFarland.
Thank you, Mr. Chairman. My question for the witness is, and I noticed that we're having this conversation right on the back of HB 1501, and so when I look at HB 1509, does it not create an extreme perverse incentive for judges not to render bail decisions justly, but instead to keep certain types of accused persons off the street, no matter what the circumstances are? And so in that sense, when you're thinking about real breaches of judicial immunity, what do you consider to be the real types of issues that are substantive issues for judicial immunity discussions, and do you think that this bill waters that down?
So to address the first part of your question, I would agree that a potential unintended consequence of this bill would create a strain on judges to consider external factors, subsequent civil lawsuit against them when determining a bail decision, and that would essentially also put a judge, the Judicial Code of Conduct would not allow for that. And so that puts a strain on a judge to consider external, where it would be improper for them to consider external factors and to take into account a potential civil lawsuit that may follow them when determining rendering bail. That would place a judge in a very uncomfortable situation. I would note the written testimony that we provided, 3 different judges spoke to this issue on this bill and could provide further information as to their personal opinion on that, not necessarily the branch's opinion. And I apologize, would you mind repeating the second half of your question?
Yeah, it was just as to, given your comments around that, frankly, I think what I heard you say here is you're putting a judge into a sort of Morton's Fork circumstance of, if you rule one way, you are being unethical. If you rule the other way, you are subjecting yourself to potential for civil lawsuit. What is judicial immunity properly intended to protect against?
So it's essentially to also not only just protect the entire judicial system as a whole. I wouldn't say arguably it's intended to protect the judge, but to protect the judicial system. A judge who is acting properly within the Judicial Code of Conduct in considering a case should be awarded judicial immunity. Judicial immunity would not apply when a judge would be acting outside of the confines of the Judicial Code of Conduct, and as noted for the previous bill, committing on an unintentional tort or a criminal action wouldn't apply in those cases.
Representative Horgan.
Yes, I'm not a criminal attorney, any type of attorney, and I've also never been a criminal defendant. But my understanding of the bail process, including the case in Berlin, is that the judge or magistrate, the judicial officer who's granting bail, does so on a number of conditions, and the defendant, who's now deceased in the Berlin case, violated at least one of those conditions. So, to what extent should we punish a judge for making making a bail, offering bail to a defendant who agrees to certain conditions, but then doesn't follow those conditions? So, like, what is it? To what extent is it appropriate or inappropriate to punish the judge if the if the defendant agrees to do something and then doesn't do it?
So I can't speak to, as I've never been a criminal attorney, so I wouldn't be able to provide.
At least
That,
you are an attorney, so you're one step ahead of me.
yes, but I would say in those cases where a judge's performance or decision is questioned, there are processes which are put in place in the Judicial Conduct Committee, as well as I know in that matter, there was an investigation that was conducted to determine whether or not the judge's decision was warranted. And those, I think that's the appropriate process.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else here who wishes to testify on House Bill 1509? Seeing none, I'm going to close the hearing on House Bill 1509, and I will open the hearing on House Bill 1547. And is Representative Johnson? Representative Johnson, yes. Representative Johnson, welcome.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Representative Eric Johnson. My district is Stratford 11, which includes Lee, Madbury, and Dover Ward 4. I am here to introduce HB 1547 FN, an act relative to appeals from convictions in circuit court for certain offenses. To refresh your recollection, RSA 599-1 affords a person convicted by a circuit court of a Class A misdemeanor a de novo jury trial in the Superior Court. Enacted into law last year, HB 369 requires a defendant charged with a misdemeanor sexual assault of a minor under the age of 18 to elect whether to proceed in circuit court and waive his or her right to a jury trial or to immediately appeal to Superior Court for a jury trial. HB 1547, this bill, builds on the wisdom of HB 369 by expanding this requirement to misdemeanor sexual assault regardless of the victim's age, simple assault, domestic violence, and stalking. Being the victim of these crimes is obviously traumatic, but testifying in open court about them can be as well. Testifying twice in open court is an unnecessary burden on victims. The legislature studied the process of de novo appeals from district courts in 2003. Their report stated, quote, "The right of a de novo appeal was established in the 19th century when all but a few of the district court judges were lay judges and not versed in the law. These lay judges often decided matters based upon common sense rather than the law," end quote. This is clearly not the case today and cannot be a reason for maintaining the system as it is. Regarding the fiscal note, for comparison, the original fiscal note for HB 369 stated the legislative budget assistant has determined that the legislation has a total fiscal impact of less than $10,000 in each of the fiscal years 2025 through 2028. In comparison, the fiscal note for HB 1547 reads, the judicial branch states the fiscal impact is indeterminable, but could exceed $500,000 and be less than $1 million per year, depending on the number of jury trials and operational needs, end quote. This is based on an assumption that 5 new employees would need to be hired in addition to new jury costs, the 5 employees being 1 judge and 4 other support staff. I believe more data from the judicial branch is actually required. The number of cases for each crime split by victim age, minor versus adult, would be highly instructive. The fiscal note does not take into account any possible budgetary gains at the circuit court level due to fewer cases. The bill as written would not take effect until January 1st, 2027, meaning only 6 months of the current biennium budget would be potentially affected. Fiscal year 2027 is specifically given a $0 expenditure in the fiscal note. I'll end my remarks there, and I'm happy to take any questions from the committee.
Questions for this witness? Yes, Representative Birch.
Thank you. Thank you, Representative, for being here. A question of clarification. You mentioned that this would affect misdemeanor sexual assaults. I'm wondering under, because I didn't look it up, under Section 2 and Roman 2, the various sections on other assaults being affected by this. Or is this bill only affect misdemeanor sexual assaults, or the new section at line 13 and line 13 cover other assaults?
So it expands on 369 in two ways. It expands by age of the victim, and it expands by crime.
But it still only applies to misdemeanor sexual assaults.
Correct. Well, it would also include stalking, domestic violence, and simple assault.
Thank you. Could I follow up?
Yes, absolutely.
Thank you. I guess with my expertise long-term as a criminal defense lawyer, and by the way, that's different than a criminal lawyer. So I appreciate those who make references to use the term criminal defense lawyer. I'm assigned, let's say, to represent an individual charged with one of these various offenses that you just described. Let's say I'm a public defender, which I was, and I see my client, person's charged January 1st. I see my client, let's say January 15th or so, and my client's supposed to decide by January 30th whether they want to waive their most important trial right in return for nothing. And let's say the rape kit evidence isn't even back in 30 days and the like. The fiscal note notes that it's highly unlikely, and it's odd in the fiscal note, for any defendant to waive their jury right, the most important trial right, in the first 30 days. Would this accomplish anything more than just wholesale transferring a ton of cases from one court to another court, because no lawyer, no criminal defense lawyer would likely ever advise their client to just, in return for nothing, waive their right to a jury trial?
So the bill is intended to eliminate the dual trial, where someone has, in that case, gone to circuit court, lost, and then de novo appeals to Superior Court, and then has another trial, even though there was no error in the first. When writing the bill, I was intended to match the process language from 369. So presumably you've already dealt with this question in that instance. And however you felt about that case would be the same as this one. I would also mention that you all have the opportunity to amend bills. So if you think 30 days is not quite enough, you could make it 45, you could make it 60. It's up to you.
Other questions for this witness? I'm wondering, let me just ask you this question. You pointed out that the bill dealing with juvenile sexual assault victims that has just become law. I'm wondering if you think that there would be any value before we sort of went beyond that bill to seeing how that bill works for a few years, what effect it has as it exists, and then, at that point, making a decision as to whether it should be expanded in the way you've proposed in this bill.
So I guess it depends on your point of view regarding the value. I guess the first thing is that it has been in law since the first of the month. And so there is presumably at least some data having been on the books for a few weeks. I suppose that there is an argument to be made that, if you want to let it go for 6 months or let it go for a year and then see what it is. But I think, in my opinion, 3 years is an excessive amount of time. I don't think you need that much in order to figure it out.
No, I'm sorry. I didn't mean to interrupt you. Go ahead, please.
No, I'm a CPA by trade, so auditing a small number to infer the larger number is something we do all the time. So, the data you'll have after 3 months, I would expect would be similar to the data you would have after a year, the data you would have after 3 years.
All right. Other questions for this witness? Seeing none, thank you very much.
Actually, if I might ask, similar to the point about amending regarding the days, you could also presumably amend regarding when it is enacted. It doesn't have to be enacted January 1st, 2027. It could be enacted March 31st, 2027. Up to you.
Yes, Representative Perez.
Pardon my forgetfulness. Do you recall what the bill number was last year that we passed?
369.
Thank you.
All right. Thank you very much, sir. Thank you. Next, I'm going to recognize Representative Kelly Potenza, please.
Thank you. Just for the record, Representative Kelly Potenza, Stratford District 19. Chairman, Vice Chair, and members of the committee. So thank you for the opportunity, of course, to testify on HB 1547, an act relative to appeals from convictions in circuit court for certain offenses. Last year, of course, this legislature and the governor took an important step, and a principled step, really, by enacting protections for minor victims, recognizing that our justice system should not repeatedly subject victims to re-traumatization through duplicative trials and procedural gamesmanship. HB 1547 builds directly on that bipartisan reform and extends the same basic protections to misdemeanor victims of all ages. At its core, this bill is about fairness, dignity, and finality. So, ending the cycle of re-victimization. So under current practice, adult victims of misdemeanor sexual assault, or domestic violence and stalking may be required to testify multiple times, first in circuit court and again in superior court, simply because a defendant can wait until after conviction to appeal for a de novo jury trial. This process forces victims to relive traumatic events, often months or years later, with no evidence and no facts, only repetition. HB 1547 ends that practice. I'm not sure if you guys remember, I was the prime sponsor of the bill that passed before because it was literally affecting my family personally. So we never got the chance to even have a trial. So everything was pretty much thrown out, and it went on and dragged on for 2.5 years because they know how to do that. So this bill is in the fiscal note, which I'm very happy that the previous representative, prime sponsor, was talking about, is just ridiculous. I mean, the amount of savings that could be that could be had here is huge. I can't even imagine what it costs the state for my district court process of multiple hearings, cancellations. Then they required a Richards hearing, which was then had to have 4 attorneys for the witnesses. I mean, it was just insane, and all to be thrown out for speedy trial when the defendant was the one that gamed the system to make it so it wasn't speedy. So this bill basically requires a defendant to make an early informed choice, either elect a jury trial by immediately appealing to superior court or proceed in circuit court with a knowing and voluntary waiver of the right to a later jury appeal, confirmed by a judicial group. So this framework already exists, of course, in law for minor victims, and it simply recognizes the obvious truth: adult victims deserve the same consideration and protection from needless re-traumatization. My daughter's going to turn 18 at the end of March, and this would protect her in the future. And I can tell you right now that even though my daughter is technically going to be an adult in a couple months, she is not. She is still a teenager. And I think it shouldn't matter whether you are 16, 18, 25, or 85. This really should apply. And it helps with so much. It helps with everything, kind of having with due process and having things be speedy, and actually giving victims something that I don't really think that they've had in this whole process. So this bill doesn't, of course, eliminate jury trials. It still preserves defendants' rights while protecting victims. It doesn't predetermine guilt or innocence. Every defendant retains the full constitutional right to a jury trial. HB 1547 merely requires that the choice is made up front rather than after a victim has already endured a full trial and testimony. Importantly, the bill mandates the circuit courts conduct a knowing, voluntary, and intelligent waiver colloquy before proceeding without a jury, ensuring defendants' rights are fully protected at every age. So I think this really sends a clear message that the system should not be used as a weapon. Repeated retrials, they're not neutral. They impose real emotional, psychological, and financial costs on victims and their families. When allowed basically as a routine tactic, which is what they are now, they risk turning the justice system into pretty much a tool, I believe, of continued harm. I can't even begin to tell you the harm that my family has suffered because we had a family friend that did that to my kid. So I just would love to see us move forward with this. I know for a fact when everything was going on with my bill, there was discussions at that point on making it more that it was. I know how this legislative process works. It's a beast. So you guys were able to push it through. We were able to push it through on the other side of the body. And there was talk at the whole time like, hey, well, let's add this in. No. Let's just get one piece of it through. Now, because I know that there was interest in doing it fully, that's why we're here. I really appreciate Representative Johnson for taking this on. This is truly a bipartisan bill. It's a wonderful bill. And if there needs to be some tweaks that are put in there, fine. This is yours, and you're very competent, Chairman Lynn. So I'm hoping that you guys will move this forward in an ought to pass motion.
Thank you. Questions? Yes, Representative Birch.
So, talking about tweaks and changes, and hopefully Representative Johnson, who also suggested the same thing, can hear what I'm asking. If one were to agree that 2 bites of the apple is not a good thing, where I practiced in Vermont, all of the criminal cases were in one court, the lower level court, the district court, except for homicide cases, which were handled by the Attorney General, and they were in Superior Court. Would you, either of you, consider amending this kind of bill to have all the criminal courts cases in one court, perhaps not the homicide cases or whatever, which would eliminate the 2 bites of the apple, but also not require people to waive a fundamental constitutional right in order to perceive in certain manners? Would that be something that you might consider?
I am not in any sense a legal scholar, but I'm going to say no. And the reason why I'm going to say no is because in talking with a public defender specifically about this in Concord, and then a prosecutor up in the North Country, they actually believe that so much of these cases, like if you are truly innocent, you're going to want to have you're going to want to have that right off the bat. Most of the people that don't want to have to go through all of that kind of stuff anyway. They're going to go on the district court level. All of that communication will be honest and upfront. You're not waiving any right. It's going to be informed consent. You're going to know exactly what you're doing at that point. So I don't think that a lot of these don't ever see a jury trial. The only time they're usually seeing a jury trial is after a conviction, and then it'll just drag it out for another 2 more years. If we actually had a trial in the circuit court or the district court, and then we went to Superior, this would have dragged out for, my daughter would have been over 18 at that point, and most likely it would have gone on for about 4.5 to 5 years for a misdemeanor sexual assault.
Other questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman. I know that the witness is already familiar with my opinions on HB 369, but given that
I'm
one
not
of the
familiar
arguments,
with your opinions on it at all.
well, we did discuss it. I'm not here to testify. My question is this. One of the arguments which was presented for HB 369 passing was precisely the issue that it was victimizing those young children to have to go and do this twice. And so if that was the reason that the bill last year was passed, what argument would you make to suddenly flip that on its head and say, no, this is not about the fact that these are young children. This is about the fact that we should just change the way it works for everyone without regard to the status quo, without regard to those constitutional protections.
I don't actually believe that this wasn't just for children. Of course, I think it's harder for kids or for minors than it is necessarily for an adult. But like I just said, an 18-year-old is considered an adult. Why would we ever want to re-victimize victims? Like, that just doesn't make any sense. That's a gaming of the system. So we should protect all people, not just, of course, minor children in this regard. So the bill was put forward because of an issue that I saw and that it was explained to me very clearly from both sides of the aisle, meaning a public defender as well as a prosecutor. And I talked to multiple prosecutors about this as well, because they know that it happens. And even the testimony that you guys received, you saw that. So, and I do remember there was a former prosecutor in Merrimack County, I believe, that came here and told you that this really should apply moving forward, besides, of course, just children. So there's no bait and switch here. It should apply for all victims. I don't think anybody should be traumatized at all. So,
Other questions for this witness? Seeing none, thank you very much. Next, Mr. Tangway.
Thank you again, Honorable Committee. My name is Robert Tangway, and I'm changing to oppose this bill, and I have some reasons.
You're here in opposition to the bill. Okay.
Correct. I'm a victim of sexual violence. My first time in court was when I was 5 years old. I had no problem. I love it. It's one of my first memories. They did a great job, and it was attempted. So I was smart enough to stop it at 4.5, but it still went through. You're not a victim unless there's a conviction, and that's the problem that judges say. The victim, it's alleged victim. If there was no crime to be committed, it hasn't been proven that a crime was committed, then there is no victim. You can't just go in there and say that I'm a victim. That's a victim mentality. The thing is that I do understand bringing a alleged victim or victim in twice, but there's a famous saying. I think it's Ben Franklin. I'm not sure, but it's better to let 1,000 guilty people go than one innocent person get convicted. And the process of it is, if you're facing 10 years, you want to get it done as quickly as possible. You might make a decision, which brings you to a jury. But your life stops until you're innocent, and then it's always already damaged. Police, prosecutors, they all get to choose who to prosecute. Literally, you're immune. A prosecutor's immune, and the police are immune. For if someone was to go into the police station and say, hey, Bill, what's going on? Yeah, I killed the person. I did it, non-self-defense. I planned it all out. And then the prosecutor, and then the police go, yeah, well, we're just deciding not to arrest you. Literally, they have prosecutorial immunity, and they have immunity. So you have an alleged victim. There's a case in Manchester that happened recently where a police officer got charged with domestic violence. I won't say his name because he was acquitted on a bench trial. And the only reason why I think there were charges is because the person alleging it had a lawyer. So the police didn't want to get sued, so they referred it to Attorney General, and then the prosecutor didn't really try. There was so many mistakes, and then he got off. But they're not prosecuting the woman for lying. So it's all about reform. So the penalties are very, very high, and if a jury hears, they're not gaming the system. The system's already gamed, as they charge whoever they want. So that it's very important that people have a jury trial. I would be okay with this if there was an opportunity to then change later. What if you get a biased judge? Like literally, it's up to the judge. It's up to the judge if you have a bench trial, and they could pretend. But then there's also time for the parties to come together and come up with a deal. The deal is reform. So that's what it's not to extinguish humanity as required by the Constitution. It's for reform. Now, sexual assault, I don't know what kind of sexual assault would be a misdemeanor. I mean, I guess getting drunk and not having consent, but like if you bring a weapon into it, that's gotta be a felony. That's pretty much it. So I do oppose this unless you amend it to have a second bite at the apple. You should have as many bites at the apple because it's good for reform. I don't believe in the death penalty because you need to find out why the person did it so that it doesn't happen again. And I think it's very important that we don't box someone into a bench trial. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much, sir.
Saving for after lunch.
All right. I don't think I have any other pink card. Anyone else wish to be heard on HB 1547? Seeing none, I'm going to close the hearing on HB 1547. Now, I know that some people may be interested in getting lunch. On the other hand, I also know that we have an awful lot of bills to deal with, and I'm wondering if there is some interest in speaking personally. I think that there are several bills that we might be able to exec now. I'm thinking specifically of 1501 and 1509. What do we think?
I think it's fine to go ahead.
All right. So why don't we go deal with 1501 first? And I'm wondering if I have do we want to just have a general discussion first, or do we want to have somebody make a motion? All right. All right, I will recognize Representative Smith.
Yes. Mr. Chair, on House Bill 1501, I would move ITL.
All right. Is there a second? All right, hang on. All right, so Representative Smith moves ITL on HB 1501, seconded by Representative Manos. Representative Smith, do you wish to speak to your motion?
Very briefly, we all know that these are parlous times. We are faced with questions about all three branches of government, and are we doing the best that we can do? But until we have another form of government, I believe we have to assume that 250 years of having three separate but equal branches of government have generally stood us in good stead. I am concerned about this particular bill because I do not think we will end up with a better judicial system if we were to adopt this. And I think that the arguments that were laid out by several sitting judges and some comments by the deputy, who is the general counsel these days? Thank you. Indicate that the end product of this is that while we now have a system where judges do not have immunity from actions that are defined, this bill does not accomplish that.
Anyone else? So I guess I'm sorry, Representative Perez.
Thank you. I have to respectfully disagree. Right now, we have the fox watching the hen house. So all of the testimony that we got was the fox watching the hen house. I think the state of New Hampshire has some very, very concerning issues that have come forward in the past couple of years. And people know about it, hear about it, and they're very unhappy about it. And I don't mean just at one level. I mean at all levels of the judiciary. I have seen things happen that I am taken back by when the little guy was stepped on over and over and over again. I think it's time that we need to have some accountability for everyone. Everybody screams that, laws apply to everybody. They don't like what this person's doing or that person. It's time we had a way, and if we wanted to relook at this and rewrite it, but it's time we had a way to have everybody be accountable. Now, I'm not saying that all justices or anybody are wrong. I worked in the medical field. We had some pretty bad physicians too, and they protected each other. And I watched it happen over and over and over again. People have been told, don't bother to sue malpractice because you won't get anywhere, because they will protect each other. I think we need to have a process That is not the fox watching the hen house.
All right, any other comments? So I guess I would just say, very briefly, that I understand in sort of a general sense, the concern that, you know, maybe there's something wrong in some respects, but this bill just doesn't, to the extent that this bill suggests, which it plainly does, that judges are immune from criminal liability for committing crimes or from civil liability for committing torts. It's just not true. They are not immune from those kind of things. And you know, one of the things I believe it was Mr. Tangberry, but one of the witnesses started to make reference to Judge Introcaso's case. Judge Introcaso, in fact, was prosecuted. She wasn't immune from prosecution. Now, you know, the argument, I suppose, was she got a great deal, and that she shouldn't have gotten such a great deal. I wasn't involved in that case. I don't know whether the details of it. But what I would say is this bill doesn't address that at all. There would be nothing in this bill which would prevent a prosecutor and a defense lawyer from arriving at the same kind of deal. So I guess my view is this bill is just totally unnecessary and contains provisions which could create a lot of mischief. So I would share Representative Smith's view that we should ITL this bill. Anyone else wish to be heard? All right. Yes, Representative Scully.
Thank you, Mr. Chair, for recognizing me. Welcome back. And I
Thank you.
apologize for being late. There was an
No.
accident.
I was driving up too. I know it was a tough day.
I consider this a hugely important issue, and I do think that everybody, Caesar's wife must be without any doubt, and we must make sure that our judiciary is held to the highest of standards because of the incredible power that we give them for this. So I feel like this issue needs to be looked at more. I am going to vote against ITL because I would prefer that we do interim study so we can try to get this right, because I do think that there should be absolute immunity for things that are done within the scope of one's office, but I also think that we need to hold everybody accountable for actions that are outside of it. So that being said, I will vote against this. And if another motion is made for interim study, I would vote for that. All right.
Could I respond?
Yes, of course.
Thank you. In terms of what my colleagues, Representative Perez and Representative Scully, have said, in the words of my father-in-law, I agree with them, not 99%, but 100%. There are problems. There is no question that there are problems. I could give a laundry list of problems. I just don't think that this bill is the vehicle that will solve the problems that are of concern to all of us. And this committee has the power under our own rules to conduct investigations, to look into things that we might want to do. There's no way that we're going to be able to do it with 70 bills and a few weeks to hear all the bills. It's not the way to handle responsibly the legislation that's before us. All I can say is we need another vehicle. This vehicle isn't the one that can address your legitimate concerns.
You know, I'm sorry, Representative McFarland, I'm understanding you have to leave very, very shortly. Is that correct? I mean, are you coming back? Are you coming back or?
Yes.
Oh, okay. When? All right. So, when will you? I mean, when will you be able to be here this afternoon?
Yes, with the proviso that I'm scheduled to introduce two bills downstairs at two different times this afternoon. I'll happily get with you afterwards, Chairman, and let you know when that will be.
All right. Yeah. All right. So maybe we'll exec this bill right now. If anyone else wish to be heard? All right, then the motion before us is ITL. And I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Rep. Alexander.
No.
Rep. Tripp,
Yes.
Rep. Andrews.
No.
Clerk votes yes. Rep. Perez,
No.
Rep. McFarland,
No.
Rep. Scully,
No.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. Page,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
13-5.
Well,
If there's not a lot of people talking to it.
all right, sure. All right, 13-5. All right, Representative Smith, can I ask you to write the?
Not only may you ask me, but I accept.
All right, thank you. And
Representative Perez, sorry, Mr. Chair.
will there be a minority report?
Yes, and I believe the motion would be OTP,
All right.
not IS. I know Representative Scully wanted IS, but I believe OTP would probably be better.
Perez, okay. Okay, all right. All right, then, next I propose we turn to, HB 1509, and Chair recognizes Representative Birch.
Thank you, Mr. Chair. I would move ITL.
Is there a second?
Second.
Motion made by, Representative Birch, seconded by Representative McFarland to ITL. Representative Birch, do you wish to speak in favor of your motion?
No, I think we just heard the bill.
But no,
Excuse me?
thank you, sir. No. Thank you, sir. Thank you, sir. You're out of order. Hang on. All right. Anyone else wish to be heard on HB 1509? All right, are we ready to call the roll? I'd ask the clerk then to please call the roll.
Vice Chairman Mannion,
Yes.
Rep. Alexander.
Nope.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
No.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. Page,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
16-2.
All right. Representative Birch, can I call on you to write the report? All right, and will there be a minority report on this?
So nice.
I
Can it
almost
go
want-
on the,
Can I,
Can it go on?
can I keep you posted? I almost want to write one. Can I let you know?
Well, you could, you can keep me posted until the end of the day, okay? All right,
For now, yes.
all right. All right, maybe. All right, all right, yeah. So let's take a break, until 1 o'clock. All right,
I'll be introducing Bill next door at 1.
1 o'clock,
16:39.
16:39. All right.
who was that other one?
All right. All right.
Yes.
All right. I'm going to call the Judiciary Committee back to order. I apologize, we're a little bit beyond 1 o'clock. And I'm going to open the hearing on House Bill 1639. And, whoop, hang on. Find the bill here. 1639. And I'm going to recognize Representative Kelly, prime sponsor.
Good morning, Mr. Chairman and members of the committee. I am Diane Kelly, Representative Diane Kelly, representing Hillsborough 32, and I am here to introduce HB 1639 regarding grand juries. Other states provide grand jurors with instructions and handbooks or both, and within those, essential information is provided, including the fact that grand jurors are public officials responsible for investigating citizen complaints of corrupt actions by politicians, bureaucrats, and corporations. This bill is designed to put into statute duties and obligations grand jurors already have. Additionally, petition-initiated special grand juries are being created to address issues of significant public concern. I'm going to leave the specifics to former Representative Jason Gerhard, who's been providing educational materials, including grand juror notebooks that the grand juror notebooks that were emailed to you guys earlier prior to this hearing. He has done research into other states and can provide you with background on this important institution that has been accurately called the People's Panel, because this is where the power lies. And with that, I will leave the rest of it to speakers following me.
All right. Questions for this witness? Seeing none, thank you. Next, Sheriff Bill Wright, please.
Good afternoon. Thank you. My name is Sheriff Bill Wright. I am the Sheriff of Belknap County. I represent the New Hampshire Sheriff's Association. I am the president of the association, and I'm here to testify in opposition to this bill as it's written today. Part of the reason that that we have opposition in this bill is that there are several things that involve federal oversight by county sheriffs or county employees, county attorneys, and such, that we think are not applicable to our positions. We do not have any oversight as it relates to how the federal government operates within their established facilities. Specifically, in this bill is introduced, it talks about federal institutions, correctional property, and that we don't believe that that we would be the people to be doing that. There's also some things within this bill that talks about inspections of detention and care facilities. We believe that at this point, it's already being done through New Hampshire RSA 30B12, which every 6 months the county commissioners are required to do the inspections and do the reports on those buildings. We don't, again, as sheriffs or as county attorneys, we don't believe that that's our position to be doing that. We do agree that that there are times that you know, the grand jury should be convened, of course, to discuss different things, but we believe that the reporting processes and who it gets reported to and how the investigations are conducted would not fall in line with how we traditionally do our investigations here as criminal investigations with the sheriff's offices. And we also do civil investigations as well. That's part of our jobs as sheriffs. And we just don't believe that this bill as written will provide the spirit in which we need to actually do our jobs and when we're doing it. So for that, we ask that that this bill be ITL'd.
All right. Thank you. Questions for this witness? Seeing none, thank you very much, Sheriff.
Thank you.
Next, I'm going to call on Joseph Nugent. I think that's from Jefferson. Yep. Come on up, Mr. Nugent.
Thank you, Chairman. And members of the committee, I wasn't quite prepared to come up right after the sheriff's testimony, but I'll do the best that I can. I believe that this is another example of accountability and checks and balances that former Rep. Gerhardt and others who are representing this bill as proponents. I'm for the passage of this bill. We're just missing out on constitutional rights. Earlier this morning, we've heard many other issues that have been mentioned, such as the Judicial Conduct Committee. You heard the public nickname for that. We're just not getting traction for the protection of our rights. And I feel that this constitutional remedy has been reserved for the people, in my understanding, to look at government and make not indictments, but presentments to law enforcement officials or prosecutorial people like the county attorney and attorney general or the U.S. attorney, and that just is not happening in our state. So I think that this bill goes a long way to trying to empower people to be part of their government. Everything is being done. Everyone spoke this morning on the committee saying we need a remedy. This bill or that bill might not be that remedy. I think this bill is another bite at the apple to try to find the remedy that the people have been petitioning for, remonstrating for. Unfortunately, we're almost to the point now where we're begging and pleading. So I would just like to say that I'm for this bill. I think it provides remedy that the people are seeking.
Thank you very much, sir. Questions for this witness? Seeing none, thank you. Next, Representative Mike Edgar, please.
Good afternoon. Thanks for this opportunity to speak to you on this bill. Basically, before I forget to say that I'm not in favor of it, I'm not in favor of it, and I hope you ITL it. I was hoping, I was coming here to hear what people had to say about the bill because I was a little confused about it. And I was hoping to hear more people speak first, but, and maybe that usually I don't speak if I don't think there's a reason to, but I guess I do now. I was really shocked at the extent of the bill, what it was going to get into. It was like a shadow government in a way. I think there's an awful lot of ways that we have, especially in this state, to track and to give our input on how we feel about things and to try to affect how they're implemented. The checks and balances we have, I think, for example, I think are pretty exceptional. There's opportunities for people that a lot of times they don't seem to take advantage of. If you go to like a lot of the county meetings and things, it's usually not too many people from, except, we hope to even get all the legislators there, but there's not too many other people that are around to give their opinion on anything, really. I think there's a lot of ways to try to do that. I'm a lawyer, but, like military and civil, but so some of the other stuff that I might say, might just be completely wrong, but grand juries, I thought they were pretty much held, and they're held in secret. The people that testify are usually held in secret. I assume that that's the way this is going to be done with this one. Those that are involved that are maybe accused or being investigated, typically not notified it's happening. Of course, with some of the inspections, you'll know if you're being inspected, but for some of the other cases that they have here, and then typically I thought with grand juries, it wasn't just issued to the public without the people that are being investigated or whatever having a chance to speak. It's just sent out there. I just think that's wrong. I think there's ways to take care of and investigate things or investigate people that exist right now. And I think we ought to use the tools that we have. So it's pretty much more than I was going to plan on saying, but if there's any questions for me, I can give it a shot.
All right, questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Next, I'm going to call on Richard Samperl, please.
Good afternoon, Mr. Chairman, members of the committee. Thank you for the opportunity to address this bill. I actually have a letter I would like to submit to the committee if that's possible. It's 4 pages, so I have no intention of reading it, but I would like you to have access to it.
That's fine.
My name's Richard Samper. I'm a resident of Portsmouth. I'm a practicing lawyer. I've been practicing in the state of New Hampshire for just over 30 years. I have a law office in Exeter. Most of the work I do is criminal defense in nature, but I do some other things as well. I am also an adjunct professor at the University of New Hampshire Franklin Pierce School of Law, where I teach. I've taught a variety of courses, including criminal procedure and trial advocacy. I'm not here in that role today. I'm only here in my personal capacity as a lawyer. And I've also served on, and I do serve on the Judicial Council, and was serving as their interim director at one point. But again, that's not my capacity today. I'm just here as an experienced lawyer to share with you some of my views about this bill and what I think is a problematic form of legislation. I should start by saying I think it's probably well-intentioned to give some oversight to various government agencies and to make sure there isn't mismanagement, to make sure funds are being used appropriately, that individual citizens are treated properly. I just believe that using a grand jury for that process is a deeply flawed way to approach that problem. To give you just some examples of that, a grand jury is a secret closed proceeding. The public can't attend. The persons being investigated or entities being investigated may not even know that they're being investigated and may not know that there is an opportunity for information to be given against them. There's no record of what happens at a grand jury. Those grand jury proceedings are secret proceedings. This bill doesn't do anything to change that. If the information is going to be compiled into a report, the evidence that's being used to furnish that report and to author that report remains secret under grand jury proceedings. So therefore, a grand jury report might be publicly available, but the evidence supporting it won't be. Grand jury proceedings are one-sided proceedings, which means that the people who are the subject of the grand jury proceeding, or the organization that is, or the state agency, doesn't have an opportunity to rebut any information that is presented, or to present a contrary view, or to argue that the evidence that is introduced should be interpreted in a different way. The rules of evidence don't apply. That's okay, but it makes for an unreliable result here. Witnesses can come and testify about information that they don't know personally. That's hearsay, that's double hearsay, even triple hearsay, and other things that make evidence that would normally be admitted in a courtroom unreliable. And there's no applicable standard. So typically when we're talking about grand jury proceedings, we're talking about a process to identify criminal wrongdoing, not civil or tortious acts. And the importance there is, at the end of the grand jury proceeding, there is either probable cause to charge someone with a crime or there isn't. That standard is not present in this bill, and it allows for the issuance of reports without identifying any standard at all. Presumably, the reports would rely on less than probable cause, because if there was probable cause to believe some misconduct occurred, there would be a criminal charge resulting. So if there isn't a criminal charge resulting, the resulting report clearly is not even rising to the level of probable cause. Under this bill, the person who is leading the grand jury, if that's a prosecutor or a grand jury foreman, it's not clear to me who that would be in reading this bill, but that person gets to direct the narrative and gets to cherry pick the evidence in writing the report. And that's really problematic in terms of using this type of tool to get objective, reasonable, transparent information that is complete. And a grand jury proceeding would result in a criminal charge, and therefore there would be another process where the evidence could be tested. But in this bill, there is no provision for testing those conclusions or challenging any of the resulting information in the report. And so just to sort of conclude here, As I was saying, the purpose of a grand jury traditionally is to identify criminal conduct. The majority of jurisdictions in the United States do not permit it for other purposes. And there is no historical basis in New Hampshire that I'm aware of that allows a grand jury to be used for investigatory purposes that do not focus on criminal conduct and result in criminal indictments. And using it for some other purpose like that really creates a danger. It creates the import of a judicial document, and I'm quoting here from some of the material in the letter. Yet, even though it has the import of a legal document, its principal attributes, the right to answer an appeal, don't exist. It furnishes no form of denial. No one knows what the evidence and findings are based upon, and an indictment can be challenged and defeated, but a presentment or report cannot be. And so for all of those reasons, I would strongly urge you to oppose this bill, certainly in its current form, with the one exception that I think giving some jurors more than $10 a day is probably a pretty good idea as someone who tries cases in front of juries. I know it's not a huge amount of money, but I really do get a sense that jurors would appreciate some greater recognition than $10. I'm happy to answer any other questions if you have.
Questions for this witness? Seeing none, thank you very much.
Thank you, Matt.
Mr. Sanford, Attorney Sanford. Next, Jason Gerhard, please.
Jason Gerhard, Northfield. Trying to think of how to start here. So there have been some, I believe, incorrect statements. And I want to start with, I learned about the grand jury and what they're capable of doing through reading this book, The People's Panel, Grand Jury of the United States, 1634 to 1941. That was written in 1963 by a history professor down in Texas. And I learned so much in there, and much of which is encompassed in the handbook that I emailed everyone here, the Grand Juror Notebook. And I made this because I am giving this out to the grand jurors as they report for duty at the Superior Courthouse in Merrimack County. And I have received a lot of positive feedback. Some of the people who are there giving information out with me are behind me. And the jurors want to know what their job is because for some odd reason, the state of New Hampshire does not provide them with a juror handbook, instructions, or even a guide, which other states do. Notably, New Jersey has a very detailed one, and Florida has instructions and handbook, which are golden. And I'd like to just briefly quote from them in a second. As far as there being no history of the grand jury doing any investigations in New Hampshire, I would encourage you to look at one of the pages in the handbook where in the late 1600s, the town of Dover was presented by the grand jury for failing to maintain the town's stocks. That was actually in the People's Panel. And the reason I bring it up is the grand jury was created in 1200. It was brought over from England, and it is such an essential part of our government that in Scalia, in one of his decisions, Williams, a famous Supreme Court case, it says, in fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. And I quote, unlike a court whose jurisdiction is predicated upon a specific case or controversy, the grand jury can, quote, investigate merely on suspicion that the law is being violated, even because it wants assurance that it is not. Going back, somebody mentioned the word presentment, and I think, well, I did not know what this word meant, and I think it's important to read the 1828 Webster's definition of it really quickly. In a more general sense, presentment comprehends inquisitions of office and indictments. In the United States, a presentment is an official accusation presented to a tribunal by the grand jury in an indictment, or it is the act of offering an indictment. It is also used for the indictment itself. The grand jury are charged to inquire and do presentment make of all crimes, etc. The use of the word is limited to accusations by grand jurors. What is important to remember, there are two facets to the grand jury. One is their accusatory role, Prosecutor walks in, hey, I want to accuse Jimbo for selling crack. They either issue a true bill or a no true bill. True bill is an indictment, boom, carries forth. They have probable cause, now he goes to a petite jury. Because the grand jury is 23 members. The other role is the investigatory role. And they can investigate anything they want, which is so critical in these times where if you try to get anything investigated, I was a former state rep. And the reason I left is because basically it's a waste of time as far as investigations go. You guys can't even, well, even though you're allowed to under the RSAs, put people under oath before they testify. If you try doing that, you will soon find your chairmanship taken away from you, which to me is the most absurd thing, that there is no requirement that anyone tell the truth. Perjury is important. The truth is important. The people deserve the truth. As going to I just want to go over the Florida Grand Juror Handbook very briefly because it raises some interesting points. Also, let's actually stop first with Ohio. Their Grand Jury Service of Citizens Guide specifically states, as a grand juror, you are a public official. They are public officials. But when I tried to inquire how I could present before the grand jury, my county attorney in Merrimack County told me that he could not tell me. That is legal advice. The idea that we have public officials who are not able to be approached by people, the people, is just absurd. And these grand jurors do not know about the role that they have. That's why I'm out there giving them information. And I'm going to continue to do it. The clerk's cool with it anyway, but even if she wasn't, I'd still do it. I'm getting a little flabbergasted because I just find this so frustrating that we have members of these professional organizations that are trying to tell us something isn't when it is. The grand jury is truly what will get us out of this whole mess. Florida Grand Jury Handbook. Charges of crime may be brought to your attention in several ways: by the court, by the state attorney, or the statewide prosecutor, from personal knowledge brought to your body by any member of the grand jury, and lastly, by private citizens, who have a right to be heard by a grand jury in formal session and with the grand jury's consent. And it goes on from there. I do want to address some of the comments that the sheriff made, namely that RSA 123.1, titled Jurisdiction Over Lands Acquired, Tax Exemption, it specifically says that any land ceded to the federal government, the state of New Hampshire retains concurrent jurisdiction. So as far as I'm concerned, the state of New Hampshire has not given up jurisdiction to any building, including the federal courthouses. And that's why part of this bill discusses the review of federal sentences that may be excessive and so forth, and to bring back those federal prisoners to New Hampshire state custody so we can figure out how to rehabilitate them the best. Because as someone that did a dozen years in the federal prison system, it's pretty bad in there. It is a complete waste, and I think it's a jobs program for the most part. It's human warehousing. As far as the county commissioners overseeing the county jails, they do a walkthrough once every 6 months. If you've ever actually been in a county jail and you see how that goes down, they lock you in the cells. You got some people that do a little walkie-do, and that's it. They send out the Brown Nose Brigade to give them some, story about how they've, found God or something. But it's all kind of just smoke and mirrors. The last part I wanted to bring up, which now I kind of forgot because I'm jumping around too much. Yes. California, 58 counties in California, they have civil grand juries. And this is from the county of Glenn, which has a really good history of the grand jury part on their website. But even the Civil Grand Jurors Association of California has sample forms to fill out. It's amazing. The grand jurors in California are required by law to inspect the county jails, penal institutions every term, and also to pick out a government agency, department, and audit them. That's fact. I mean, and also I don't even know where to start. As somebody that kind of got into this, I realized this is really the way to do it, because I'll close with this. Hopefully somebody behind me can kind of mop this up. But real quick, 3 paragraphs, then I'm done, I promise. In the 300 years and more, this is from that book, The People's Panel, since grand inquests first convened on American soil, panels of representative citizens have spoken out against all manner of threats to individual liberty. Agents of the British Crown, territorial political appointees, meddling abolitionists, corrupt machine politicians, corporate monopolies, racketeering criminals, and many others have had occasion to know the wrath of an aroused grand jury. Although the object of their investigations has shifted from place to place throughout the years, grand juries have remained guardians and spokesmen of their communities. Grand juries have the effect of placing criminal justice in the hands of community members. They possess broad inquisitorial powers derived from a constitutional republic, yet they are of the people, not the state. By constantly changing personnel, it prevents small groups from gaining a vested interest in law enforcement and gives all persons an opportunity to participate in their constitutional republic. The grand jury enables the American people to act for themselves rather than do an official act. It is the one institution that combines the necessary measure of disinterestedness with sufficient authority to effectively investigate malfeasance and corruption in public office. Today, as in the past, it is the one body that can effectively handle the complaints of individual citizens, whether the grievances against their fellow citizens or the government. And with that, there's so much in this book. It's awesome. If anybody wants a copy, feel free. I'll give you. I got a bunch. I'm open to questions. As I said in a previous hearing, I'm just tired of this whole just trust me, bro, from government people. We don't trust them. The government's out of control. And this lead article I was going to mention with Claremont, the $5 million missing. If we had actual functioning, educated grand jurors, that kind of stuff wouldn't happen. I mean, look at this. Look at the State House. You guys track every penny. You know, it's really, we just kind of lost control of this government. It's gotten out of control, and I think that this is an effective way to do it. And at $20 a day that you're paying them, pretty good cost-saving measure. So,
questions for this witness? Oh, Representative Alexander.
Thank you, Mr. Chair. Thank you, former representative, for taking my question. I have a question. Do you know why? Do you know why grand jurors don't receive? I'm seeing that they receive like a pre-recorded audio video presentation, but like not additional like knowledge of what their rights are.
yes, I actually spoke at length. Thank you for the question. I spoke at length with the clerk last week, and it turns out I wanted to know the process. Well, actually, first off, what they receive in educational materials. Nothing. Just the orientation video. Did you watch the orientation video? Okay. It's pretty interesting, and I didn't want to bring this up, but that orientation video, the judge in it, the Chief Justice of the Superior Court, he served from 1992 to 2000. If you guys got to watch that video, it's on Vimeo. It is just a throwback to the 90s. It is amazing. And the best part is his daughter. It's so old, this video. His daughter retired in 2023. So it's not just a matter of that they're not provided any instruction materials, which I think is a tragedy in itself. But the materials they're given are designed to be the utmost, most boring thing. I watched it. I regret to say that, but I did watch it in its entirety, and it doesn't cover anything. And the best part is when it goes to the history of the grand jury, it puts on this cheesy, medieval music, and it's useless. So,
Yes, Representative Perez.
Thank you, and thank you for taking my question. So it sounds like we're behind the 8 ball to some of these other states that are way, way ahead of us. Can you explain to me what possessed you to get behind and forming this grand jury association?
yes, it's fake. I don't take any money, but the New Hampshire Grand Jurors Association, I find when people are kind of walking up in a court situation, it looks better than just me, popping up. But the reason I did it is from an article that was in Reader's Digest from 1930. It was titled, 1935, The People's Big Stick. I highly recommend reading it. And it's about how in New York City, they created the grand jury was already called into being. It was a standing grand jury. But the grand jury wanted to look into some corruption, and one of the county attorneys refused to look into it. He says, as far as racketeering and prostitution, major prostitution rings back then, which, with Epstein now, I guess it's kind of all circling back. But they refused, the prosecutor refused to look into it. So the grand jury said, you know what? We're doing our own thing. They went to the governor, and they got a special prosecutor, and they cleaned house. Lucky Luciano was one of the main people that was taken down. It turned out to be $12 million prostitution ring back then, which was huge. But the point of the story is that is the culmination of the New York County Grand Juror Association was started in 1913. And it was to educate grand jurors as to their real duties and obligations. And that's what I'm doing. So maybe it's 20 years down the road, we'll see fruition from this. But I thought this hearing was a first step because honestly, I'm quite frustrated and I don't want to say upset, but disappointed that we have the judicial profession, let's say, circling the wagons on corruption and telling us that, you normal people who show up for $20 a day, which is a tragedy. That's why I put that 200. But that you don't have the ability to look into these things. You can't figure that out. It's going to take our legal magic to kind of let you know what's wrong. Because there's a lot going wrong, a lot. So,
Other questions for this witness? Seeing none, thank you very much, sir.
thank you.
Next, I'm going to call on Bobby Wayne or Warren. I think it's Wayne. Bobby Wayne.
Hey everybody, my name is Bobby Wayne. I like the last part, what Jason just said. This is a big deal, there's a lot of prosecutors, judges, and law enforcement that won't go after corruption because, quite frankly, everybody's scared of everyone and it's very violent out there. So pulling together a grand jury to help this along with the peers of who we are is a big deal. And I think everybody knows that. So thank you.
All right, questions for this witness? Seeing none, thank you very much, sir. Next, Daniel Richard, please.
Is this live? It is live.
Yeah, it's on. Yep.
Ladies and gentlemen of the committee, thank you for your time today. I'm a historian. I want to take you back in time as to the previous law that was on the books here in New Hampshire. The very first grand jury law was written by the state legislature in 1792. And I want to talk about the two things that are relevant to today's hearing. One is the selection of the grand jury, and two, the presentment power of a grand jury. Number one, the original process by which grand juries were selected was done at the local level. They would hold a special election process, and those persons who were chosen would be the makeup at the local level and independent of the judiciary. Today, the legislature has seen fit to transfer that local power and the independence at the local level to the county attorney, the clerk of every county court. So when the selection process is now controlled by the judiciary, it's no longer controlled by an independent body. Now, I want to talk about the presentment power. The Fifth Amendment to the U.S. Constitution still says that the indictment power and the presentment power are still part of our makeup of our rights. So what does the presentment power look like? The presentment power is designed specifically so that that people at the local level can investigate whatever it is they want to investigate. From truancy, I found it fascinating that truancy from school used to be an issue, and it would be referred to the local citizen grand jury, and to investigate anything that it feels might be inappropriate. Now, it forms a very important safety net here because these investigations would be done in secret. So a public official's reputation or anyone in the community would preserve and protect their identity unless, of course, they find that something's wrong. The next part of it would be to, let's say it finds that someone at a local level or at the state level has violated some rule, ordinance, or regulation that only warrants possible sanction or corrective action. Then the grand jury could do that very thing. It could find an issue of presentment. The next thing is, if it finds that it's got a great story about this is in Florida at the turn of the 20th century. The local grand jury found that the local tax collector was not properly securing the tax revenue of the citizens. So they made a recommendation that a locked door was insufficient, that we needed a safe. And so the presentment was made, corrective action was brought about. So the next part was, if the independent grand jury finds that they think that something rises to a criminal level, then they only get the ability to make the presentment to the county attorney or the local attorney, because he's practiced in law, and that's why he has a law degree. And so he would decide whether such proceedings would continue. And this is a far stretch from what we have today. Today, what we have is our grand juries only sit in the capacity to rubber stamp or evaluate that which is presented to them based on criminal prosecution. All lesser violations or infractions that could be, solutions could be presented so that we could deal with these at a simpler level, but that doesn't happen anymore. So now the citizen grand juries only perform that task, and that's it, and no other. Questions?
Any questions for this witness? Thank you very much, sir.
Thank you.
Next, I will call on Robert Tangway, please.
Robert Tangway here. I'm for this bill. I'm very upset actually that you guys ITL'd the two other bills.
Let's go, but let's focus on this, okay?
There needs to be some corrections, and it all ties together. So the totality of the circumstances, which is by Supreme Court, U.S. Supreme Court, recent ruling, I think in the last session. You have no way to sue a judge. You can sue a judge, but it will get dismissed. Absolute immunity, civil immunity. That even extends to 1983. The only way you can bypass that is if they lack all jurisdiction. All jurisdiction, meaning they're not in the courtroom, they're not judges. So you guys need to reconsider that. This bill's immense. But it stems from Article 8 of the New Hampshire Constitution. And holding government officials accountable, well, you go to the police or you call the attorney general because someone stole your kid and took him out of state, violating 633:4, which is a felony, which would require a grand jury indictment, because that's what grand juries are for felony charges. That's how you push it through. There's actually a statute. I don't know the one often, but I guarantee you there's a statute, because I've read it, where it requires before they start prosecuting, they have to have a grand jury indictment for felonies. So Hans Marconi, felony indictment. Justin Nato, felony indictment. Secret. One-sided, as they said. One-sided. Now, this is basically to, in my view, is to hold the government accountable. You all have your own interests, okay? You're not doing it for $100. Maybe you're doing it for legacy. Somehow you're able to afford to be here. I have to go DoorDash to be here. I was homeless for a year because a judge wrote physically and mathematically impossible findings of fact, and then the lawyer conveyed those for a very long time. So there's no relief. So if the police protect the judges, and the judges protect the judges, and the lawyers protect the judges, and the attorney general protect the judges, and the judges are all lawyers, and only one of our Supreme Court justices was ever a judge, and they're all appointed by Governor Sununu or Kelly Ayotte, it's like Sweezy versus New Hampshire, where it was all Republican. So there needs to be a third party, and the third party is the people. We have all sovereign rights. And it's the 250th anniversary of our Constitution and the Declaration of Independence. Our Constitution came out first. So I recommend some changes to this, though. I think that you guys should reconsider the previous bills that you ITL'd and instead have this go to study. And then you can look at that holistically, because this can be abused too. We live in a republic. If everybody says Robert Tangway is a bad guy, I have constitutional rights. They can't do it. You can't vote on me. There's a big problem with power and money in politics, and this committee is here, in my assertion, to protect the judiciary. That's what it's here for. And those ITLs were voted ITL because they don't want to expose our judiciary, which we have a constitutional right, Article 8. The government shall be accountable at all times, the government. Further, the judges are required to be bonded. They're not bonded. Chapter 93. So nobody's doing their job. This provides a way for the people to gather 500 signatures and do the job for them. It's a one-sided thing, but that's, I guess, what a grand jury is. So that's where I'm coming from with this. And also Article 8 stems with 91A requests, which the government constantly denies and sends you in circles. So Article 8, the people with a petition of 500 can investigate anything and get all these documents, the documents that are trying to be hidden. So I do support this bill, but I think that it needs a little bit of work, and I would think it would as a couple limitations so that it can't be abused against people. Corporations have a contract in the state of New Hampshire to follow X amount of bylaws, just like when you get married, just like, and also RSA 311:1, any person can prosecute. That's what it says. And 311:6 says that a lawyer has to take an oath to not do anything for lucre or lucrative. Our government is for money. You guys are here for money. You guys are connected to money. Ms. Smith's connected to previous Administrator King, Judiciary. We have a problem. That's why these bills all today exist, because we have a problem. I would really appreciate some questions, especially going forward, because I believe that I'm not being fully heard and considered without any questions, especially when you vote against. And I can't coerce you to do anything, but I can try to persuade you. And if you have any questions, I'd be happy to answer them.
Questions for this witness? Seeing none, thank you very much, sir.
I would like to commend the committee, though, for giving people time to speak. That is very important, and I appreciate it.
Thank you. All right, next, I'm going to, Patrick Binder, please.
All right. Good afternoon, everyone. Patrick Binder from Manchester. I'm here with New Hampshire First. We're a citizens advocacy group, and I think this is generally a pro-citizen bill. It was said earlier that this doesn't create anything new. It actually just adds structure to something that already exists. It's not in our Constitution directly, but Article 90 of our Constitution is the part that brings in common law that was in practice in 1784 when the Constitution was written. And that same article says that we can't get rid of common law without actually repealing it. And from all of my research, there's nothing in our history that repealed grand jury presentments. What we ended up with was just a court that ignored them and ignored them long enough that no one, people weren't asking for them. And now here we are asking for them again. As it was mentioned, hundreds of years ago, these were created. And they were created exactly for the same reason, because the people were upset. They're upset with prosecutors not doing their job or doing their job maliciously. It has to go both ways. It has to be a check both ways. So currently, the prosecutorial indictments, all they're doing is, as was said earlier, rubber stamping what a prosecutor wants to do, right? But there's no other check. How do we make the prosecutor do something? How do we check on the government? And that was the original purpose of these. They've been around for hundreds of years. They never left our laws. It's never been repealed. And so because of that, I think this bill's a good bill because it is adding structure, modern structure again, to something that's already existed and been a useful part of governance for our tradition, our English tradition, for hundreds and hundreds of years. I think it's time for them to make a good comeback and be used. And if there's some part of this bill that needs to be worked on, work on it. But something like this needs to happen. If we're to look at Article 3, this is the part of our Constitution that says why we form government. And it is to protect the natural rights in Article 2. But it also says that in order that we give up some rights in order to protect others. And without such an equivalent, the surrender is void. If we don't have the power to protect our rights from the government, then the surrender is void. And then we start looking at what? Article 10? We don't want to go that route, right? No one wants to. This government needs to do its job, which is to respect the powers of the people, to put a check on the people. and that is done through grand juries. I think this is a workable bill that has a good system so that people can actually access this power of the grand jury, and so that the grand jury knows that they have this power.
Thank you, sir. Questions for this witness? Yes, Representative Alexander.
Thank you, Mr. Chair. Thank you for taking my question. I'm considering amending this to just start baby steps, just start requiring that the courts train and educate grand jurors. Would that be a step in the right direction? I understand it wouldn't be a whole bite of the apple, but
I mean, yes, I think you could get rid of, say, like the petition process, but they need to be educated on both of their powers. As it is right now, so there is an RSA to define how prosecutorial indictments work, right? But that doesn't say that the other power of the grand jury just went away because the court defined what the prosecutor's responsibilities are. The grand jury's responsibilities and obligations are still there. So as long as it's the full obligations, I think that's a great first step, is to tell them, hey, here's all your powers, both sides of them, right? Yeah, I think that would be a good step.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Therese Basteranch. I hope I'm pronouncing that. There you go. Thank you.
Thank you all. My name is Therese Baster-Ashlad in New Hampshire, and I have to honestly say this is probably the most exciting piece of proposed legislation I have seen in my 4 years of being politically active here in New Hampshire, and I will tell you why. I come to you today as a previous foster mom who adopted 2 little boys out of the state system, and right now I'm actively working with 5 different biological moms who have gone through they're facing TPR. They're facing the termination of parental rights. And when you look at their entire case, and I actually still have people that work for DHS and work for DCYF from a ministry I once did, who have actually looked at their case and said this one went completely off the rails. To take a child away from a parent when there's not true just cause really should go before a jury of their peers. And I see the potential for this. I know that our court system here in New Hampshire is horribly underfunded compared to other states. I go to the executive council meeting when they're trying to fill a position for a judge and they have no inventory. We have a crisis in our court systems. And when the judges are overtaxed and they're overburdened with cases, and one of them makes a bad decision, they back each other professionally. And I understand that and I get that. And I understand why errors happen, because they're not funded well, they're not staffed well. But at the end of the day, we really don't have a mechanism in place to prevent really some catastrophic outcomes. And my heart would just beg for you guys to take a look at this. I think that this was our founding fathers really putting a provision in place. It's cost effective. I believe it does belong with the sheriff, because the sheriff is one that we, the people, elect. We don't get to elect our judges. They're appointed, and they're appointed because there's only one person to pick from. So it's not like we have the strongest, and I hate to say this, but Attorney Gent, award-winning attorney in Boston, he says the judges are the ones that couldn't make it as an attorney, because you can make a lot more money as an attorney than you can sometimes as a judge. I don't know if that's true or not. I'm just a nurse. But I'm here to tell you that my heart, for everyone involved in the court system, my heart cries for them, because I can't imagine what it is to do that for your vocation, for your entire life identity. But I got to tell you, there's outcomes where we need the people to come together and look at something with fresh eyes and discern whether this feels just or whether it needs to be reevaluated. And I think this is the mechanism that allows that to happen. And I would just pray that we would resurrect this and use it to its fullest, optimize it, use it to its fullest potential for the people. We've got people who are concerned about money and NGOs, waste, corruption. I think regardless of where you are in the political spectrum right now, the heart and the pulse of the people, the voters, is please do something to stop waste and corruption. Make sure my tax dollars going to the disabled individual, to the veteran who's homeless, to the orphan, Let's make sure it's being used wisely and correctly. This brings accountability, it brings integrity, it brings engagement, it gives the people a voice. It's absolutely beautiful. And we could be first in the nation to truly resurrect this, and it could be a game changer, I believe, for the entire country. I hope that you will just take it into consideration, the potential you have with this to do something really, truly amazing for potentially a child who may never see their mom again.
Questions for this witness to be heard on HB 1639? Seeing none, I'm going to close the hearing on HB 1639, and I'm going to turn the proceedings over once again to my vice chair, Representative Mannion, because I'm the sponsor of the next bill.
And with that, I'm gonna, you got the time yet? Not yet. Yeah, okay. Open up the hearing on CACR 9. And I recognize Chairman Representative Bob Lynn to introduce this bill.
Thank you, Mr. Chair and members of the committee. I'm Representative Bob Lynn. I'm from Wyndham, Rockingham District 17, and I'm here in support of CACR 9. If this bill sounds familiar to you, it should. It was here last year or 2 years ago, I guess. It was passed by the House. It was passed by the Senate by the required 60%. It went to the voters, and it needed to get 66 2/3. My recollection is it got 65.4 or something like that, which was close but no cigar, as they say. I'm not going to spend a lot of time on this. I think I personally think that there should be a limit, a judge age limit, unlike in the federal system. But I also think that 70 is just too young. And you know, I should say, this, just so it's absolutely clear, even 2 years ago, this bill would have had absolutely no effect on me, because by the time it was voted on, I was already over 75, and now by the time this would be voted on, I'd be over 77. So it has absolutely no effect on me, but I think it would have an effect on some very, very good judges of both, who are appointed by both Republican and Democratic governors, because despite what we've heard today from a number of people, I think that the judicial branch in this state is outstanding, and I think, candidly, that it has gotten better and better since the time that I was first appointed. The judges who have been appointed by both Democratic and Republican governors over the last 20 years or so have been outstanding. And many of those judges would be able to serve for another 5 years. And I think there's no reason not to do that, and it makes a lot of sense to do that. That really is all I have to say, and I'm happy to take questions.
Thank you. Any questions? Representative Alexander?
Thank you, Mr. Chair. Thank you for taking my question. In your experience as a judge on the bench, did you find there ever a time when the appointing authority, the governor, could not find a qualified judicial nominee under the age of 70 to serve in the role?
Yeah, candidly, no, I don't think so. No.
Representative McFarland? Thank you, Mr. Chairman. And I would be pleased to congratulate the representative on his youth. But I guess my question is, with regard to the fact that, as you said, this has been presented to the voters recently, why is it appropriate and necessary to be putting the same question to them again so soon?
Well, when you say, is it necessary? I mean, I have to, I guess, no, of course it's not necessary, but is it appropriate? I guess I think that where it came that close, that it makes sense to give it another try. One of the things that I have thought about, and I'm thinking about actually preparing a proposed amendment, is to just change the way, not the bill itself, but just the way the question would be presented, because I had, again, this is anecdotal information, but I did receive some information that some people were confused by the way the question was put to the voters the last time. And some people actually thought that that they were voting to impose a 75-year age limit, where none existed previously. I don't know, candidly, I don't know whether it is legally possible to change the way the question is worded, but it might make, if it could be done, it might make sense to say to the, in the ballot question, here's what the Constitution says now, paragraph 1. Paragraph 2, here's what the Constitution will say if you pass this amendment. Paragraph 3, paragraph 3 would be the question, do you support the amendment? I think that might be a clearer way of doing it, if it's possible to do that.
Any other questions? Representative Horgan?
Well, my first question is kind of a small detail, which is there's a reference to judge of probate, which of course I assume doesn't exist anymore. So what were judges of probate?
There are judges of probate. They're now circuit court judges, but they serve in the probate division. So,
yeah, so they're covered either way.
Right.
And follow up. The second question is, and why is this structured as just? So you're striking the language from Article 78 and adding some. Is there any particular reason why we're not doing it as Article 78 and Article 78A with the part about the judges? So have separate lines in the RSA for the sheriffs and the judges.
No, I mean, other than that, the way to keep it as close to the original language as possible, I think probably makes sense to do that. But it could be done the way you suggest.
Fine either way, but thanks.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Representative Kelly Potenza?
Thank you, Mr. Chair. Just for the record again, Representative Kelly Potenza, Stratford District 19. I wasn't planning on speaking on this bill, but I am, just because I strongly do not support it, and for a number of reasons. So first, based upon what Representative McFarland said, this was just put to the voters. And I have to say that I worked the election when it was on the ballot the entire day. Because I represent pretty much all of Rochester, I had to go around to every single ward. And they had people that were working the election that were walking up and down the lines and in trying to explain what this meant. And I would have to tell you that I then, because there wasn't one person that was doing that all day long. So most people, when they don't understand the question, they don't answer it. They leave it blank. So I probably spoke to, I don't know, hundreds of people that day. And every single time I spoke to them about it, they were all against it. No one wanted that. And part of it is we are carving out a specific thing for judges versus sheriffs and things like that. So if we're going to do this, we got to do it across the board. Why are we just carving it out for an age increase for judges, but not for sheriffs? So I didn't talk to anyone that wanted this. And as I assume that you all know, the judges are currently judges that are over 70 right now. They're all currently, if they're still wanting to work, they're all currently working. They're all working in our courts. They're working as referees. It's already happening. There hasn't been much change at all. I understand that that wouldn't be the case for a Supreme Court justice, but for all the lower courts, it's already happening. So I have actually, in my time, in the last 3 years being in the court, I've never had a judge that wasn't a referee. So, and I think he was 73 years old. There was another one that was 75. So it's already happening. They're there. They make decisions. They go back to whoever the quote unquote sitting judge is that is, of age. And then those decisions are made. I think the people didn't understand the question at all, but that doesn't mean that it's going to give you a different result. I think you should explain it better, because how it was asked, of course, on the ballot was people weren't understanding it. And again, it's in all fairness, if we're going to do this, we have to do it across the board. We shouldn't be carving out a specific circumstance for judges alone. And the people have already spoken. And yeah, I don't think that you should move forward with this bill. So that's it.
Thank you. Any questions? Seeing none, thank you. Robert Tangway.
All right. Robert Tangway here, author of New Hampshire Oliver Twist. I recommend that you guys all read it. Be working on modern Oliver Twist eventually. I am not in support of this bill, unfortunately, and I have great respect for my elders and the wisdom, especially Rep. Lynn. I love hearing him speak, and I think he's thoughtful. But there's a saying that I wrote. You can't teach an old judge new tricks, but it's easy to trick an old judge. So my first time in court in New Hampshire, besides when I sued Amazon, which the FTC took up that case on the same grounds and was denied by Gordon MacDonald when he was Attorney General. I had a referee who just recently retired, and she wrote physically and mathematically impossible, not likely, not more than likely, ponderance, and that is why this is the first time I spoke in the State House. It was afterwards, and I've been retaliated against it. She wrote that I looked into a sliding glass door that doesn't exist, that I initiated 1,100 texts for 3 months, no legal standards, and I haven't seen my children in over 3 years because of that. And you want to hear a man howl, cry, take away his children, especially I was never arrested, never charged. We found out now they went to the police. And
what does this have to do with the age of a judge?
Because a judicial referee wrote down physically and mathematically impossible findings of fact. Impossible. And then they destroyed the evidence, knowing that a judicial complaint was filed with the Supreme Court. It's really horrendous stuff. There's ego. There's also wisdom. I would agree to this if our judiciary wasn't so corrupt and disheveled. Government is inherently corrupt. That's why we have a constitution. I could never be a judge. My ego is through the roof. That's because I came from nothing. I have to. That's my defense. We want wise judges, not teeny boppers, I'll call them, which is who reviewed first-time rookie. We want the wisdom, but again, they make mistakes. And I feel that this bill would have the effect of elongating political appointments, which is the problem. That's the real problem. I will say that my videos get more views than just all the legislators. So if you guys ask me some questions and want some good promos, if you ask a good question, it shows up and thousands of people see it. So that's my testimony. I just want to reiterate that a 70-year-old judge, a judicial referee, wrote physically and mathematically impossible findings of fact that have been transmitted all across the state, including now. So the officer who was there, if you get pulled over, it shows that I looked into a sliding glass door that doesn't exist. That's fraud, and fraud unravels all. So I have to get things situated so I can see my children, but we have to deal with other things. So I think that this would be something that could pass, just not now. And there's other opportunities including in the last bill, for retired judges to make $800 a day almost. It's a lot of money. Thank you very much.
Thank you. Any questions? Seeing none, thank you. Joseph Nugent?
Hello again. Good afternoon. I'm testifying today in opposition of CACR 9. That's a little bit of a tongue twister for me, sorry. I'm against this bill to amend the Constitution regarding the age group because I've spent far too much time in the court since I've come here to New Hampshire, and I'm specifically thinking of one instance in the Carroll County Court in Ossipee where a judge that's been complained about for years was conflicted out on a particular case that I went to as a witness. And there was a referee there. I'd love to name him by name so that you all know, but I'll respect the wishes of the chair not to do that. This was a retired judge, former Marine, and he did not have the mental acumen in order to hear the case. In this particular case, it was a DV matter, and my friend was accused of domestic violence, where the accuser had actually previously been arrested for domestic violence against the person who she was now accusing. And the retired judge didn't have the mental acumen to even understand what was going on, and because my friend was the gender of a male, he assumed that he had been the one who was arrested. And he wrote this order that way. But the testimony was completely different. The story was that his son's mother had been arrested in a previous altercation and had been, charged and arrested for domestic violence. But this judge didn't have the mental acumen, and he was still doing that. There's the difficulty that it takes for someone to fix errors like that, even in the family, administrative courts, statutory courts. I believe it's like nearly the equivalent of a college thesis to run and navigate your way through the Supreme Court. If anyone's never had the hellish experience of having to defend yourself before the New Hampshire Supreme Court, it would be very interesting as a member of this committee to talk to people who have, because it's nothing less than like a college level thesis. And to submit someone to have to do that because the judge didn't have the mental acumen to even hear the facts of the case properly is why I'm against this bill today. I've seen it in person. This person ended up getting violated over a phone call because of that, and found to be dangerous and held in jail that year from Thanksgiving over Christmas and New Year's on something that he shouldn't even been able to get under this administrative action. And we just don't have enough checks and balances to stop the atrocities that are happening in the administrative court. I really hope that we can find ways to remedy that. and stopping this amendment to the Constitution, I believe would be one way to do it. Thank you for your time.
Thank you. Any questions? Seeing none, thank you. Daniel Richard. Pass. Okay. I don't have any more pink cards for this bill. Anyone here that wants to speak on it that hasn't turned a card in yet? Seeing none, I'm going to close the hearing on CACR 9. I'll turn it back over to Chairman Lynn.
Thank you. We can start. All right, so I'm going to open the hearing then on CACR 20, and I recognize Representative Sellers, please.
Good afternoon, Mr. Chairman, Vice Chair, and committee members. Representative John Sellers from Bristol, New Hampshire. I represent Grafton 10, Bristol, and Bridgewater. I'm here about CACR 20, which is ultimately to repeal Part 2, Article Amendment 72A. And if you look at the bill itself, just read the last from lines 20 down to 26. And really the last 24 to 26 tells you exactly what this is going to do. You know, and you know, you can take a minute and do that. I'm just going to bring up what also is on the bill because it is part of it. So in Part 2, Article 4, back in '66, I've done a little bit of history on this. They put together a resolution to put in 72A. And in there, it never mentioned anything about strike through of line 3 on the first page. So it never mentioned that. But in any case, what that did, it stripped the general court of the ultimate power we have. All right, that's what it did. Because if you look at line 4 on the first page, it says power and authority. That's our power and authority. That should be from us because we're the elected. Judges are not elected. So they elect us to make sure the courts and what needs to be done in the state is ultimately in the hands of the people. And that's the Republic part of this as far as that goes. We're their representatives. So if you don't strike or get a repeal 72A, then the judiciaries have their own power. They make up their own laws. They make up their own rules. And they can't be overridden at all by the general court. So it basically stripped us of the power, and it stripped the people of the power. Now, back in '66, I have no idea if it was a Republican or Democrat to put this resolution together. I have no clue. I didn't go that far. And I did not go back to find out how many votes it passed by either, but it would be interesting information to look at. But what I am saying is looking at this 60 years later, literally 60 years later, if we vote on it this year, at least 60 years, that one, a solid generation, if not 2 generations, already passed. And things have changed. And back then, they might have said it was Republican versus Democrat or Democrat versus Republican. Whoever was in office decided that, hey, we'll do away with the court, you know. And they said they had problems 4, 5, 6 times before. I think we're better than that at this point. It's 2026. The information, all we have, I think we wouldn't go and dismantle court system. All right, that's just going to put more work on the legislators at that point. But right now, we don't have any authority over it. Unless I'm wrong in reading this, we don't know that 72A stripped the general court of its authority, meaning it stripped the people of their right and their authority. So why they did it back in '66, I don't know, except for what they said. But I say it's time to actually bring this back to the general court. That's what we're here for. And if you look at the branches of the government, at that point, it actually lists the legislative branch first, We're supposed to be the most powerful branch in checks and balances, then the executive branch, and then the judicial. That's how it's supposed to be. So I don't want to keep going on, and I'm not going to try to beat this thing to death. I think you all have read the Constitution here or there, and hopefully through more than once or twice. But I hope you see the logic of this and why I brought this CACR forward. Thank you for your time.
Thank you. Questions, Representative McFarland?
Thank you, Mr. Chairman. My question is, and thank you for your testimony. My question is as regards the voter's guide on page 2 at the end of the CACR as introduced. Would you agree that the language of that voter's guide, if anything, is in fact misleading by omission? And would you be supportive of a committee amendment which would change if the amendment is adopted language to read something along the lines of, if the amendment is adopted, the Constitution would be restored to its original form as adopted in 1784 and maintained until 1966, under which the General Court forever has full power and authority to erect and constitute judicatories and courts of record without the limitations imposed by the 1966 amendment?
No, thank you for the question, and absolutely, that makes whatever makes more sense and clarity for the voter. I mean, can you imagine if all these CACRs passed and we had them all on the vote, on November? We'll be reading through 10 pages just to try to vote. So, and we need a clarity for the voter. They got to be able to read it and understand it. And as Representative Lynn said on the CACR 9, it may have been not so clear for the voter, and they might have been misunderstood or confused, what they were voting for. So anything that you guys could think of that you think if it's amended needed, absolutely, I agree with you.
Other questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Next.
Thank you very much.
Going to call on Representative David Love, please.
Thank you, Mr. Chair. Thank you, committee, for hearing my short testimony. As a member of the Children and Family Law Committee, we hear all kinds of accusations against the court. And one of the bigger ones is the family court rules. Rule 1.2, okay, waiver of rules. As good cause appears, as justice may require, the family division may waive the application of any rule except where prohibited by law. That's just way too much wiggle room for me. We originally had the right, the legislature had the right to make the rules, and we gave it up. And now we're letting the fox mind the hen house. For me, and it seems like after a lot of testimony, that a judge, just because he likes a lawyer, can figure out a way to waive the rules and waive rules of evidence. Waive rules of due process, waive rules of anything. Okay, there's wiggle room in these rules to get around anything, and we as a legislature need to take it back. That's it. Thanks.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Robert Tangway.
We're almost done here. Okay, so I actually have the legislative book, and I've talked to the clerk. Article 72A is completely, well, not completely, fraudulent. The voters were presented, and then after it was voted on, they added a sentence, the legislator, from what I can procure, added a sentence that the rules shall have the force and effect of law. Fraudulent. That's our government. And this was after Sweezy versus New Hampshire, where it was returned from the Supreme Court, the U.S. Supreme Court, Cold War sedition. But before, I believe, I thought it was in 77, but the 200th anniversary was in 76, right? And then now we're at the 250, but it doesn't fall on a cool little 76 year. But it's a better number, 250. And you'll see that with the history of the legislature, as I read all the laws now to get my life back in order, you'll see that after these times, there's a lot of movement back to the Constitution and such. But this is fraudulent. And so it was done for political means by the elite to gain power. They literally added words to our Constitution after it was voted on to give the force and effect. So all the court rules, the rules of evidence, the Superior Court rules, the Supreme Court rules, have the force and effect of law. I don't have to follow court rules, especially if they're repugnant to the Constitution. Lawyers have to. They took an oath to do that. A lawyer is a officer of the court. Their first duty is to the court. Second duty is to their client, which is a ward of them. It's a ward incapable of representing themselves, taking liability off the client for the most part. But to the court also is to the opposing counsel and opposing party. So that's why we have this big problem where all these rules have the force and effect of law with a fraudulent constitutional amendment. In order to rectify this, I don't know the exact process. This should pass, but I bet there's another way to do it. I bet you can actually remove, I don't know how, remove the last sentence. And then it will be okay. At least it won't be fraudulent. And so that's where I'm really at. But it's a real big focus on the court rules. They can waive anything. 1.2, same thing in Superior Court. The rules of evidence, they can waive the rules of evidence, all on a whim. Lie, cheat, and steal, hope you fail on appeal. That's what happens. I've had 3 Supreme Court appeals, all for procedural issues. They struck my brief, all while Hans Marconi is getting indicted. Like, it's ridiculous what's going on. But this is just more evidence of the government is inherently biased. A lot of people that sit in, especially family committee, don't know the law. They don't know anything. They're like, I want to be on a committee. I think it's the people that run the committees that do know. And that's why I asked for your leadership, Mr. Lynn, because you do know what's good. And I think you're a good person. I don't think people wake up and go, let's screw Robert Tanguay over. Let's screw the poor over. I don't think that they have the understanding, because if you go through the judiciary, if you go through, which the lawyers are, judges, their whole family's judges, just generational wealth gets passed. And then people who get affected by bias, and the judges aren't following the laws. I have it all written, like they have it, signed affidavits. You have left with no opportunity to better one's station in life. And that's what this is really about. That's what our Constitution's about. And to have a judiciary create law on fraud, it's pretty self-explanatory. I'll be happy to take any questions about the court rules, the family court rules specifically. I think that's the isolated area of unsettled law and where we're having most of our problems. You go into Superior Court, those judges are seasoned and such. Are there any questions?
Questions for this witness? Seeing none, thank you very much, sir.
I would like to remind you all that you have a duty to repeal this. I will send you the actual voting logs, register. I have it all. Thank you.
Okay, all right. Next, I'm going to, Lauren Warner, please.
Good afternoon, honorable members of the committee. Again, my name is Lauren Warner. I serve as Deputy General Counsel of the Judicial Branch. I'll be very brief. As noted, this bill proposes to remove the Supreme and Superior Courts as constitutionally created courts, which was done in 1966. I would only note, I note the The last time this bill was in front of this committee was in the 2012 session as CACR 25, which this committee ITL'd the bill, and I'll just read the committee notes. This would repeal Article 72A, Part 2nd of the New Hampshire Constitution, which mandated that the Supreme and Superior Courts are constitutionally established and therefore an independent judiciary. The bill would subordinate an aforementioned courts to the general court. Despite the legitimate concerns with judicial access, which may have occurred since 1966, the all but unanimous and bipartisan committee opposes this amendment as it would fracture the separation of branches and unnecessarily alter the appropriate balance of power between the judiciary and the legislature. Just noting the separation of powers among the three branches. That's all I have to say.
Questions for this? Yes, Representative McFarland.
Thank you, Mr. Chairman. Would the witness agree that you in fact misrepresented what this amendment would do, in as much as it would not get rid of the Supreme Court? It would simply revert the Supreme Court to its state pre-1966 in this regard.
I might have, that would say that was slightly mischaracterized, but I said they would remove them as constitutionally established courts. So they would be up to the legislature to determine what form of court they would be, just no longer constitutionally established.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Daniel Richard, please. Oh, yeah, thank you.
I'm sorry about that. I think you got the gist. Thank you for the time again. By the way, you should all give yourselves a pay raise. When the Constitution was written, you were supposed to be paid in silver. But today's testimony is about 72A. 72A was deceptively proposed to the voters in 1966. And what no one knew at the time was that the legislature, Part 2, Article 4, would be surrendered. There's a big problem. We have case precedent on this. Gerber v. King in 1967 overturned question 8 on the same ballot as question 1. And that was that you can't, the intent of the voters must prevail. So I'd like you to sit as my jury today, and I'm going to read you the same ballot question. It's only a few sentences. So you decide whether you think that they had informed consent. Did the people know that they were about to surrender the legislature's oversight over the judiciary? Because what would end up happening, and I'm not going to get into a long list of changes, but the gentleman who spoke earlier was talking about 73A, not 72A. In 1978, we would get a repeat of the same thing. And I'm glad former Justice Lynn mentioned this, is that when ballot measures are put to the voters and they're confused, that's what Gerber v. King struck down. So 73A said, quote, "The rules so proclamated shall have the force and effect of law." That wasn't in the voter's guide. Voters had no idea. They inserted that after the fact. But let me get to 72A. I've got it here for you. This is question 1, 1966. Are you in favor of protecting the Supreme Court and the Superior Court from possible political interference by establishing them as constitutional courts? Now, at the present time, the Supreme Court and the Superior Court are not absolutely free and independent of the possibility of political interference or other tampering based upon ulterior motives. The legislature, by simply passing a law, abolished either court and may legislate out of office all the judges of that court. This has actually happened 6 different occasions in the state's history. That's exactly right. When we had a rogue court that was out of control, the legislature stepped in and removed them, shut them down. The federal Congress retains this power, by the way. They can do the same thing, but we gave it up in 1966. If the amendment is passed by enough yes votes, question 1, the Supreme Court, which is the Court of Appeals, and the Superior Court, which is the General Court of Trials, will be established as an independent constitutional courts and freed of the threat of legislative interference through the arbitrary device of abolishing the court. That's not arbitrary. That's the legislature exercising the will of the people, because now you've lost that power and no one agreed to it. So to close the final sentence, the independence and integrity of these courts are essential to protect our individual liberties and rights. 2, provide a check and balance on the powers of the legislature and the executive department. Guess what isn't there, ladies and gentlemen? Part 2, Article 4. Part 2, Article 4 is your power. It was stripped with no disclosure, no consent. Under Gerber v. King, that can't stand. The Supreme Court has already established the precedent that if you do not disclose to the voters the actual intent or outcome of a proposed amendment, it falls. Questions?
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Joseph Nugent.
Thank you again, Mr. Chairman, for your time. Thank you, members of the committee. It's tough to follow that truth from the historian that went before me, but I do have a few things that I'd like to add in my own experiences with 72A. I do believe that someone on the committee earlier mentioned that we had 3 equal branches of government, and that's true in the United States of America, but our very unique state, the state of New Hampshire, our Constitution predates the United States of America. We have historical markers around, Concord, when we ratified the Constitution. But when this Constitution was written based on, what had been written by John Adams in the Massachusetts State Constitution, we made some very unique pieces to that, where specifically in Article 4, where the members of the House can make judiciatories. That's a tough word to pronounce. I hope I got it close. It's because the judiciary became a creature of this general court. Our legislature isn't called the legislature. Our legislature is called the general court because our legislature, all of you who took an oath to protect the New Hampshire Constitution, can create judiciatories. And the issue that was mentioned before, I could highlight even more because I've been to the state archives and I've looked at the voters' guides. I've even looked at the ballots of how this beautiful Constitution was usurped from us in 1966 and then again in 1977 with these amendments. I mean, 72 is part of the county government, and in order to usurp it and put it in, they put 72A under county government. At that time, the judiciary was 73, which also mentioned that it was always judges in good behavior. That somehow was taken away at the same time. But I can tell you that the Voters Guide talked about inserting 72A in our Constitution, but it never informed anyone. I wasn't even born yet, but it didn't inform anyone that they were altering your ability in Article 4, because it only said Ibid Art 4 at the bottom of all of this. It was a complete and utter fraud to insert this because the readers at that time could only think, as you read the question, it wouldn't even take precedence in court because it would be objected to. The question on the ballot was so leading, any attorney would say, oh, leading, I object. And it was there to manipulate the voters at the time because it was written in a way that if any of us read it, we would say, sure, we want our courts to be constitutional courts. And it was a complete usurpation, which in my opinion has teeth and traction that you should all take notice of, because Article 4 talks about shall forever. It talks about the general court shall forever. But someone put a parenthetical insertion right in front of that in our Constitution. We found other mistakes in the Constitution recently that have massive consequences, but that parenthetical insertion was not part of the Voters Guide. It wasn't part of the ballot, but it says except. It was someone else who we can't even track down their interpretation of what they thought Article 72A meant. And it altered our beautiful New Hampshire Constitution from being a place where all of you, with all this representation that we have, could appoint judiciatories. And I'd like to close by saying that if you can take and make statutory courts that can violate our rights, like what happens in every single district court. I could take more time and give you all the cases of where we say we have no rights in the district court. We certainly have no rights in the family court. We're begging and pleading with you. But if you can make statutory courts where we don't have constitutional rights, then I just implore you to take the power back to create judiciatories that can solve, as it says at the end of that article, any matter in controversy. Let's just get to the matter of controversy so that we don't have to keep hearing all this testimony about how our rights are being taken away. And I believe it resides explicitly in what happened on November 16th in 1966 with 72A, and I commend the sponsoring legislator for taking this up. Thank you.
Questions for this witness? Yes, Representative Birch and then Representative McFarland.
I appreciate the fact that you and many of the witnesses have been here all day as well as I. And my question is about the complete non-mention of Article 37 of the New Hampshire Constitution, which states that in the government of this state, the three essential powers thereof, the legislative, executive, and judicial, ought to be kept as separate from and independent of each other. And is it not true to your understanding that this yes was based on John Adams' reminder that we are the government of laws and not of men? And would you also agree that this is the strongest statement of separation of powers of any constitution in the United States?
Thank you for your question, Rep. Birch. I do believe that is a strong statement, but I also believe that our founding fathers had the vision to understand, because if you look at the reading of what Article 73A, creating the judiciary, said, it gave you that control, so that if Article 37, I believe, as you said, says what it did, it was because the House, the general court, the representatives of the people, over 400 and something representatives in our state, believed that they had the power to have a check and balance on those people. So that's why I believe that Article 37 would be separate, because we still did have a Supreme Court and superior courts prior to this general jurisdiction where our rights are being taken away in the district court and all these other judicatories.
Representative McFarland.
Thank you, Mr. Chairman. I think further to my learned colleague's question, I would just ask whether you've already indicated in your testimony that you do not believe that the voters in 1966 were properly apprised of the language that ultimately was inserted into the Constitution and that you say was not on the ballot. Do you believe, however, that when it talks in Part 1, Article 37, about the separation of powers, as the representative alluded to, that it's talking about the powers and not about the bodies, and that in fact the General Court did have vested in it an element of the judicial powers, precisely as was documented and as it has been tampered with in Part 2, Article 4. And most particularly, if you were a voter in 1966, having availed yourself of the information that was available to you when you cast that vote, would you intend, even if you voted for that amendment, even if you voted to put in place Part 2, Article 72A, would you intend in making that vote that you were removing that power from the General Court?
Thank you for your question, Rep. McFarland. I believe if anyone were to look at the voter's guide and the ballot question, they would believe that any voter never thought that they were taking that power from the General Court. I believe that if they thought that was going through, that power would be retained, because it didn't come, the coup de grace came in 73A. So no, to answer your question, I don't believe that anyone knew that they were removing that power.
Thank you. Other questions for this witness? Seeing none, thank you very much, sir. Is there anyone else here who wishes to be heard on CACR 20? Seeing none, I'm going to close the hearing on CACR 20, and I'm going to open the hearing on HB 1465. And the chair recognizes Representative Corson, the prime sponsor.
Thank you, Mr. Chair, and thank you, committee, for hanging in with us all day long. You guys got to be tired. My name is Lori Corzin, and I represent Coos County District 7, which includes Berlin, Whitefield, Jefferson, Kilkenny, and Twin Mountain. I'm here asking you to consider House Bill 1465. I bring you this bill at a constituent's request. This legislation would create mandatory reporting of civil rights violations committed by members of our judiciary. This is about protecting the most fundamental rights of the people we represent, including the right to due process, the right to be heard, and the right to present evidence in your defense. Let me tell you about a mother that I'm trying to help up in the North Country. She's fighting DCYF right now for custody of her daughter. The state presented a document against her written up by a physician. This woman was able to obtain evidence, real concrete evidence from a physician, signed by a physician, that directly refutes what the state claims. This could prove her innocence. She went to court ready to present this evidence. She told the judge that she was able to refute the evidence against her. The judge told her that he has sole discretion over what evidence will be accepted and what evidence will not be accepted. He refused to let her present her exculpatory evidence that could prove her innocence. That is a constitutional violation. The United States Supreme Court has held that you have the constitutional right to introduce evidence and present a complete defense, especially in cases involving fundamental liberty interests like the care and custody of your children. It violates due process and it violates our Constitution. Right now in New Hampshire, no one reports this type of offense. The court staff who witnessed the judge's refusal to see her exculpatory evidence have no duty to report it, or they're just plain too scared to report it. The judge just moved on. The damage is done, and the mother lost custody for at least another 3 months. HB 1465 creates a simple mechanism. State employees, attorneys, judges, and court staff have a duty to report suspected civil rights violations by judicial branch members to the Attorney General. We already trust reporters in hospitals and schools to make these same types of judgments when they believe that parents are being abusive. Why not in our courts, where liberty, family unity, and fundamental constitutional rights hang in the balance? We need the people who witness these violations to have both the obligation and the protection to speak up. I ask you to support HB 1465 before another family is destroyed. Thank you.
Questions for this witness? Representative McFarland.
Thank you, Mr. Chairman. You referred, and it made tremendous sense to me in your testimony, to constitutional rights. However, your language in the bill actually makes reference to civil rights. Would you agree that civil rights are different than constitutional rights, and that what you're actually seeking to protect here is constitutional rights? And would you be willing to support an amendment that would make that clear?
Absolutely. You are correct. Thank you, Representative McFarland.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Lauren Warner, please.
Thank you, honorable members of the committee. Again, my name is Lauren Warner. I serve as Deputy General Counsel on behalf of the Judicial Branch. 1465 creates a mandatory reporting for civil rights violations and also judicial code of conduct violations. As noted in previous testimony I provided earlier today, the Judicial Code of Conduct, any violations thereof, is handled by the Judicial Conduct Committee. So as opposed to reporting judicial conduct violations to the Attorney General's office, the appropriate body would be the Judicial Conduct Committee. In terms of civil rights violations, that is generally broad in this legislation. It doesn't define what a civil rights violation would be, so as to determine what a violation might occur and for one to report under this bill, just noting that it's just overly broad, as well as potentially any civil rights violations could be brought, whether they would be employment actions, Human Rights Commission could arguably, civil rights violations should be reported to them as opposed to the Attorney General's office. I would also note this bill widely applies and makes mandatory reporters to all state employees, members of the New Hampshire Bar, state and federal employees. One potential unintended consequence of this bill, when you have for just hypothetical example, this applies to all members of the judicial branch. So whether they're judges, staff members, clerks in the court system, anyone who works within the judicial branch. For example, say a member of the judicial branch has engaged in some action they feel might be a civil rights violation or arguably violates the Judicial Code of Conduct. Under this bill, if they were to seek counsel from an attorney who practices in the state of New Hampshire and explain the circumstances thereof, that attorney would be arguably a mandatory reporter under the statute who could be liable or subjected to a misdemeanor, a fine, or potentially 1 week incarceration. But also that attorney is barred by attorney-client privilege to share that information and would be subjecting themselves to potentially attorney discipline office and their bar license. I would give another example. So the judicial branch has attorneys within it which provide counsel to judges, to branch staff, oversee employment matters, potentially discrimination matters, matters that could potentially fall under this bill. And in those cases, if as the bill is written, those attorneys within the judicial branch who provide legal counsel, as happens in the executive branch, or their attorneys within the executive branch or within the legislature that provide legal counsel, any matter covered under this bill, would be in a hard situation. They could be subjected to potential misdemeanor, a fine, 1 week incarceration, for not reporting and trying to keep their law license, or potentially violating the attorney-client privilege. So just welcome any questions the committee might have.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Mr. Tangway.
All right, Robert Tangway. And we're almost done here. I support this bill. The previous speakers, also members of the House, made some good points that I already had. I think it was McFarland. So Rule 38 of the New Hampshire Supreme Court, 2.15, makes judges and clerks mandatory reporters. But it also says that this is not the grounds for any legal action. This is kind of weird. However, RSA 311:6 requires lawyers to basically do the same under the pains and penalties of perjury, an oath that they willingly took. And since all judges took that oath, because all judges are lawyers in our state for some reason, this already exists. Now, perjury, that requires a grand jury indictment. Nobody's going to do anything about that. So this bill handles that. But again, civil tort liability, I looked it up because I was like, the first thing, like, it's super vague. It goes anywhere from like due process violations. So I think that needs to be tuned up. This is a very important bill, by the way, guys. Very important. Okay, but it just needs to be tuned up as people, and that's where you guys get to speak. I'll be watching you guys exec this, and I really want you to work through it. I mean, this is a pivotal time in our history. So that's 311:6, perjury. That's an oath that they take, and this basically just adds to criminal. I would like you guys to add, consider a civil cause of action so that you can sue. Because otherwise you're left with the restatement of torts, which I brought up earlier, where you have to find a common law tort. And this is like evolving cases that are happening in Superior Court with my lawsuit. So I'm getting this back. I mean, the way I see it, it's really simple. Someone hurt you, they weren't supposed to, you can sue. Personal injury, right? But then they like to come up with all these deviations, and even if they're right or wrong, if you're not represented, if they don't like you, lie, cheat, and steal, hope you fail on appeal. And appeals are very hard. Top-notch stuff. I got a GED. I still wrote excellent papers, which people have said are very good. So I want you guys, so those are the things that are really important, okay? These things already exist except for the criminal, but then there's a criminal perjury. Now we're talking a misdemeanor. The grand scheme of how our judiciary should run, more lawyers, would make it easier to become a lawyer, smaller penalties for lawyers and judges, and more frequent escalating. So to get people on track, we all make mistakes, but the lawyers are a racket, which violates Article 83, a monopoly in the state of New Hampshire. They are the only ones who are allowed to practice law, and they're going to hold on to it. When I was at the Supreme Court, a gentleman, a security guard, ex-CIA agent, gave me a book by Bastille called The Law. And it's a great book. It's a short one. It's like a bathroom read. But it's pretty intense, and it's famous. And it's basically like all industries monopolized. There's all in interest. Franklin Pierce, monopoly. So I'm glad we were able to discuss this stuff. I think that you guys should pass this as written, but it would be better if you guys amended it to clarify the civil, and then add a cause, a right of action, meaning you can sue for this for personal injury.
All right. Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you very much, everyone.
Next, I'm going to call on Marissa Chase, please.
Good afternoon, Mr. Chair, members of the committee. Thank you for the opportunity to speak today. My name is Marissa Chase. I represent the New Hampshire Association for Justice, which is plaintiff's bar in New Hampshire. We are here in opposition to House Bill 1465. The bill in front of me, and I have some notes in front of me. I won't read directly from a letter. Not to reiterate points that others had already made, but just wanted to restate briefly. Again, the Code of Judicial Conduct is found in Supreme Court Rule 38. We believe this law would create an impossible situation for attorneys and court personnel. A couple examples that some of our folks came up with say that counsel in a criminal case argues that their client was subject to an illegal search, contrary to their client's Fourth Amendment rights, and evidence obtained in the search must be suppressed. A judge hears the evidence and rules against the client, allowing the evidence to come in, resulting in a conviction. Counsel believes the court is wrong and has failed to correctly apply the law to the facts of the case. Normally, counsel's next step would be to file an appeal with the appropriate appellate court. However, under this proposed law, if counsel reasonably believe that the judge's ruling has perpetuated or ratified the original civil rights violation, has the judge not committed a violation themselves? If so, is this attorney not now part of a mandated reporter? Or not now a mandated reporter? If the attorney refuses to report the judge under this law, could the attorney's client not allege that their attorney has failed to comply with this law and demand that they be charged with a misdemeanor pursuant to Part 4 of the proposed law? If the court reporter or bailiff in the courtroom disagrees with the ruling, having observed the proceedings, are they not mandatory reporters under this law? And we believe that should this become law, that scenarios similar to the one I just described would become rampant. We believe that the threat of complaints arising from this law could easily have a chilling effect on a judge's ability to comfortably utilize their lawful discretion in fairly and impartially applying the law. And we believe it would cause a large strain on our already overtaxed court system and resources as well. So that's what I'm here to say.
Thank you very much. Questions for this witness? Seeing none, thank you.
Thank you.
Next, Joe Nugent, please.
Thank you again, Mr. Chairman, for the opportunity to speak today. I'm in support of this bill, House Bill 1465. I'm actually the constituent that my rep, Lori Corzine, wrote this bill for. I came down here today to speak on this bill, and I was very happily surprised to see all the other things that you got to hear from me on. But this was the reason why I came here today. This was most important to me. I know that this short section that I'll read is not unfamiliar to anyone here, but if you would grant me the liberty, I'm quoting from the Declaration of Independence. Just quickly, in the preamble, we hold these truths to be self-evident, that all men are created equal, that all are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government. So that to secure these rights, we're all here today because this founding document that we celebrate on the 4th of July with fireworks and whatnot is because you're all here to help us secure these rights. But many of the testifiers today are talking to you that these rights are not being protected through administrative law, through changes in our Constitution. So this bill is designed to create a mandatory reporter. It was a bit misrepresented by an earlier testifier. It's not all state employees, because I know that because I in fact wrote it that way, but it did not come out of OLS that way. It's only people in the judiciary, because that's where our most important rights are being violated on a consistent basis, and we have not come up as a state with a proper way to put that into check. So when I wrote this bill, I wrote this with the canon of the New Hampshire Canons of Judicial Conduct in mind. That's under Rule 38. It's considered the preamble. Quickly, it just states that judges should maintain the dignity of the judicial office at all times and avoid both impropriety and the appearance of. I'm hoping that when this came out of OLS, that the legal standard for this bill would be to have a similar legal standard with the appearance of. So my vision for this when it was written was that when rights are violated in the court, someone could report this verbally or in writing, and this would create a check and balance that would go to the Attorney General, who would then make the determination of whether or not there was a real violation of rights, and that there would be reports of all the things that we've told you about. People here on this committee were on the Child and Family Law Committee, spent a lot of time hearing testimony, but those rights issues were never addressed. And this would create a way for the, these people, they say that they might be, taxing this system, but this is what they're there for. We're here to protect rights. So myself, as a volunteer at Mount Eustis Ski Area in Littleton, New Hampshire, I'm a mandatory reporter. If I see child abuse, I am mandated under our state law to report that abuse. And what I'm saying is if people who get a job and a check from all of us in the state of New Hampshire are working in the building where it is meant to protect rights, I believe that there should be a process for being a mandated reporter to protect the rights for the reason that they're being there. It's not just to collect a check. We're all here. This was scheduled for 3 o'clock. I'm glad we're ahead of schedule. I know it's been a long day, but that's why we're all here. And, I wrote this because of what happened to Marisol in Berlin. I wrote it also for what happened to me in our courts, that this House, our government, our Attorney General, former governor, everyone wants to just make it go away and look and brush it under the rug. But flagrant violations of rights occurred that there is no means to address. Representative Lynn was on the Supreme Court when I made my appeals the first time and begged for the E911 call that was not delivered to me properly. It's been cut by 4.5 minutes that took my child from me under false accusations, never charged with perjury, okay? And then 4.5 minutes. So if we can't trust our E911 call to take the entire call, even though the sheriff's machine timestamps the calls as a 10-minute and 47-second call.
Mr.
but
Chair,
got
if I could, I don't think this has anything to do with the bill.
All right, let's get back to the.
Sure, I was trying to give
issues.
a reason for why I believe that there was a civil rights violation.
Okay, but
that
that's not,
people could
that doesn't
report.
have anything to do with this bill, does it?
Well, that's my civil rights violation, and what I'm saying, and I appreciate I can make it shorter, is that violation, could have gone and then created an answer from the Attorney General of whether or not there was a rights violation, so that we get clarity on these kinds of issues. Marisol, everyone loved Marisol, and I'm friendly with someone, my friend's wife works in the clerk's office, and she still is troubled by what happened when at that court, and she wishes that she was a mandatory reporter. I put employment protections into this bill because that person felt that if they told that her rights were being violated, that she might lose her job. And when I said, obviously no one ever thought that Marisol would be shot, or murdered, but that happened, and this person had said to me, well, my health insurance, provides for my family. And I wrote into this bill to provide the protections that whistleblower protections do not provide. It needs to be put into the statute to provide the employment protections so that someone can just say that I don't think things were handled here. I was told that they say that the judges are treated like gods, as if they can't make mistakes. But everyone in Coos County knows the judges, multiple judges, made mistakes. And this bill was written in a way to try to stop that from happening in the future here in our wonderful state.
All right, questions for this witness? Yes, Representative Horgan.
I don't know if you're the right person to ask, but whether this language was written by you or by OLS or someone else, but I'm having trouble parsing lines 4 through, well, not so much lines 8 through 10 are pretty clear that a certain group of people shall be of mandatory supportive violations, but the first part of it, I'm not sure if I followed all those clauses, like how many groups of people you're talking about. So I don't know whether you want to try to clear that up for us or not, or whether you can do that. There's this very long run-in sentence, and I'm not sure if I'm interpreting it correctly. But
Yes, I understand. Attorney Horgan, thank you for that. I felt the same way about long-running sentences when I looked at Article 4, Part 2, Form of Government, and I can see that what was attempted to be done here in this, and it was changed a little bit. I have the emails from what it sent out, but I lost the ability to make feedback at that point. I think what you're asking is in line starting in 7, State of New Hampshire, including judges, clerks, court staff, bailiffs, court security, shall be a mandatory reporter of civil rights violations. Is that what you're talking? Okay, yes. Sometimes there are people in the courts that are paid by the county, and then there are people in the courts who are paid by the state. And I think the attempt at making that very clear, like our Constitution is very clear, was an attempt to address those issues.
thanks.
Other questions for this witness? Seeing none, thank you.
Thank you.
Next, I'm going to ask Joseph Haas, please. Mr. Haas. Happy New Year to you. Please press the button so that the red light comes on. That's it. Thank you.
Oh, yeah. Happy New Year again.
Happy New Year to you.
And I was hoping to avoid this place. Joe Haas from Gilmerton. And it's now 3:12. I'll try to do it within 3 minutes. What I put on my card. Line number 8, I'd like to have added in there after the word civil rights and civil liberties. And I think you already know the reason for that because I testified on that once before to this committee, I think. And also line number 12, of a right or liberty or code. So liberty would be in there too, please. And I just have a comment on, I came in late while the woman was talking of taking cases to the JCC, Judicial Conduct Committee. And let me just give you a quick example on that. I contacted the Public Integrity Unit because I tried to get a probable cause statement to go with a criminal complaint, private prosecution against a judge, and nobody wanted to take it. The local district court, no. The local police, no. The county, no. The state police over here by Clinton Street, no. And I go to the Public Integrity Unit, and John Formella, he says, through his people there, well, you got to go there, Judicial Conduct Committee. I said, no, I sued within 2 years of the judge's retirement. You have to report 2 years after the event to the JCC. So that's a bunch of crap. John Formella, I'm sorry that he got reappointed.
Let's focus on this.
Well, that's the focus, is the Attorney General's office, make a report to the Attorney General's office. And then in the other line, number 17, it says, the Attorney General's office, there's the whole big office downstairs. Who in the office? Just the receptionist, and then it goes to whoever? Judicial complaints should go to the Public Integrity Unit. And then it says, a Administrative Office of the Courts. I've done that. I tried to see Chris Keating this past summer. He was on vacation. Doesn't he have an assistant? I tried to get Mark Howard, the supervisory judge of the Superior Courts, to work on an issue, and I never got to see him. And so it would be nice to add in number 17 too, the supervisory judge. He or she should get a copy of this also if it involves the Superior Court, please. And then I have another box here to check off. Misdemeanor, number 20, $1,500 fine. Does that entitle a person under Article 20 to a trial by jury? I think it ought to be $1,499, I think. Or maybe it's over $1,500. I forget the wording of Article 20. And 1 week, I would change to 10 days, just like Articles 22 and 23, Part 2 of the New Hampshire Constitution. If somebody is found in contempt of the executive or legislative branch, the maximum time is 10 days. The judiciary used to be under the general court. You remember Dick Bosa? He always talked about that. I don't know if you remember him or not. He was here back in the 1990s. And there's an RSA, you get 1/3 off for good behavior. So the maximum time would be 3 1/3, 3 1/3. So that's almost 7 days right there. Because when you say 1 week, you presume it's the whole week, not just a working week. And then line number 21, where's that? Somebody talked about filing a civil suit afterwards. Maybe there ought to be a penalty clause in here that the whistleblower gets a percentage of the fine. Because in the old days, it used to be no county attorneys. The private prosecutors would prosecute, and they'd get up to 50% of the monetary fine as their reward. And I think that's all the boxes I have on the what I wanted to talk about.
All right.
Except I do have a comment on what Joe Nugent was talking about, life, liberty, and the pursuit of happiness. I'd like to point out the Children's Hospital case of 1902. I have that in a New Hampshire Supreme Court case. And it says, of the life, liberty, or property, the most important is property. Because if you're not, if you have property and you're being denied the use of the property, what good is living? I'm saying it, summary wise. I mean, whoever wrote the report did an excellent job back in 1902. And the last thing I had was, Joe Nugent talked about judges making mistakes. There's a quote by, I forget the man, they go to Google, an error does not become a mistake until you refuse to correct it. And a lot of these arrogant people are not correcting their errors. That's all I have to say. Thank you very much.
Questions for this witness? Seeing none, thank you very much, sir. Last, Representative David Page, please. David Love, I'm sorry. David Page. Sorry about that.
That's okay. I've been called worse.
Thank you, members of the Judiciary Committee and Chairman Lynn. For the record, once again, my name is Representative David Love. I represent Derry, Rockingham 13. I'm in support of this bill, and it was mentioned to amend it from civil rights to and add constitutional rights, I guess. But you know, I have a story of constitutional rights being violated by a judge ignoring it. It was a pro se litigant. It was my daughter. It was about 3.5 years ago. She was staying with me, and about 7 o'clock in the morning, I started barking at her to get up and go get a job. Okay, so I got in the shower, and her boyfriend shows up and grabs the car keys and takes off. Well, he ran a school bus light. So, girlfriend not wanting to turn in the boyfriend, she wouldn't rat him out. But a day later, you know, Derry police show up and they want her to go down, and so I went down with her. And I told them the story about, you know, barking at her from 7 o'clock to 11 o'clock to get up and go get a job. And, you know, I know for a fact that at 8 o'clock when this supposedly happened, she was in that bed, you know. So anyway, you know, she ends up going to court. And first of all, the prosecutor kept me out. They subpoenaed me and kept me out of the courtroom, so I couldn't help her at all. You got a 22-year-old kid that knows nothing doing her case pro se. Okay, I finally get called in. There's one witness. I thought it was a school bus driver. So anyway, you know, I do my testimony and everything, and you know, the prosecutor was he thought he was in a barroom argument. I think I did mention that, you know, I don't get intimidated really easy. You can yell all you want, but anyway, you know, the judge didn't like that much. But anyway, 3 weeks later, after this case is all over and it's past the time when she could appeal, I found out that the woman sitting in the back of the room wasn't the bus driver, the one that signed the complaint against her. It was a woman that was on the side of the street with her kid. Okay, and I think we have a right to you know, confront our accusers according to the U.S. Constitution, U.S. Constitution, you know, Bill of Rights, and it didn't happen. And the judge sat there and let that happen. You know, when we say the Pledge of Allegiance, we say with liberty and justice for all, not just those that can afford a lawyer. Okay, that liberty and justice should be for pro se litigants too, and all too often it's not. I know in my divorce case, I was abused because I ran out of money. I was abused by the judge. Okay, in fact, there was she kept telling me I was voluntarily underemployed. Okay, my knee was about this big. Okay, with 25 yards on it, that I needed a knee replacement real bad. And I wore a pair of gym shorts to court one day, you know, and I had my pants on over them. And she said that one too many times, and I dropped my pants and said, "Look at this thing," you know. But the fact of the matter is, I was a victim of, you know, judicial abuse, you know. So was my daughter, you know, because I couldn't afford a lawyer. You know, liberty and justice for all, it doesn't happen. This might do something to fix that.
All right, questions
Thanks.
for this witness? Seeing none, thank you very much,
Thank you.
All right, is there anyone else who wishes to be heard on HB 1465? Seeing none, I'm going to close the hearing on HB. Yes, we're going to take a brief recess. I asked the Republicans to meet me down the end of the hall, and if Representative Birch, if you want to have a brief. I'm going to call the Judiciary Committee back into session to deal with some execing of some bills that have previously been heard. So just so that everyone knows, in light of the progress we have made today and my projections for what will happen next week, we will not need to have an executive session on February 6th. What we'll do is but understand what that means is we're going to have to exec all of the early bills that are left. And I think there may not be that many, but we're going to have to exec all the early bills that are left next Wednesday, in addition to having the hearings on the bills that we're going to hear. And I think there's at least two, maybe more bills that we'll hear on Wednesday that we have to exec on Wednesday. So I think in the overall scheme of things, it's probably worth the trade-off, but bring your toothbrush for Wednesday. Yes. Oh, that's right. All right. So
we just have to move.
We just have to move. Yeah, we just have to.
Limit testimony.
Right. All right. So what time did I think we're 9:30 is the first hearing. 9:30 is the first hearing. 9:30.
Can we at least put the two bills that are early bills early in that calendar?
You know what? Give me 1 second. Let me tell Sarah. Maybe I can tell Sarah to start us at 9 o'clock on Wednesday.
No, she's already scheduled it.
She just mailed it
No, forget it. Yeah. That one of them is. I'm not sure about the others.
Right after we hear it.
Yeah, we could exec. I mean, we can exec. Like right after. All right. Yes, that's always the best. All right. So all right. So first, I'm going to turn to House Bill 1067. That is the mental health court bill. Oh,
I was waiting to make a motion.
Yeah, no. And I'm going to recognize Representative Alexander.
Thank you, Mr. Chair. I move ITL.
All right. Moved ITL. Is there a second?
I second.
All right. Moved by Representative Alexander, seconded by Representative Perez to ITL the bill. Representative Alexander, do you want to speak briefly to your motion?
Yeah, I have some very serious concerns with this bill. First of all, the first thing is the fiscal note, but again, not necessarily the committee to evaluate that. The second concern I have is there was testimony from the courts that said that violent people or people that commit domestic violence or other violent acts can be eligible for mental health courts. I think that's a serious flaw in the system. I do not want violent people that have severe mental disabilities to be allowed through mental health court. Thank you.
All right. Anyone else wish to? My understanding, I was not here for the hearing on that, but my understanding was that there were financial concerns about this bill. Am I correct on that?
Yeah, I mentioned the fiscal note as my first reason for ITO.
Okay. All right. That seems to me to be a very good. I mean, although I'm a co-sponsor of the bill, and I know Representative Pearson may not be happy with me about this, but I do think that I'm not sure I would agree with you on the second point you made, Joe, but I do, Representative Alexander, but I do agree on the first point about the financial aspects. Anyone else want to be heard on the ITL motion on HB 1067? Seeing none, I'll ask the clerk to call the roll.
Vice Chairman Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes. Oh, Birch. I think you said Burge. No.
Rep. Smith. Rep. Smith. Rep. Horrigan.
No.
Rep. Page. Rep. Manos.
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron,
No.
Chairman Lind.
Yes.
Motion passes 10-8.
Do you have to ask? What? No,
No,
I voted no.
You voted no.
Yeah, I voted no.
You talked over each other for a second.
Okay. All right. All right. All right. 10-8 ITL. All right. Representative Alexander, can you write the report? All right. And who will write? Is there going to be a minority report?
Yes, there will. I will write it and it will be based on OTP.
Okay. Alexander. Okay. All right. All right. Next, I'm going to turn to HB 1230, and Representative Birch is there. Representative Tur, the chair recognizes Representative Tur.
Thank you, Mr. Chair. I'd like to move ITL on House Bill 1230.
I second.
All right. All right, Representative Tur, would you like to speak to your motion?
No, I think it's well understood.
All right. Anyone else have anything to say on the ITL motion on House Bill 1230? Seeing none, I'd ask the clerk to call the roll.
Vice Chair Mannion,
Yes.
Rep. Alexander, Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Page, Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lind.
Yes.
18 yeas, 0 nays.
All right. 18-0. All right. Anybody have any objection to it being on consent? And Representative Tur, can I ask you to write the report? All right. All right. So I'm next going to turn to CACR 25, and I guess I would ask, is there, does anyone have any interest in making an interim study motion with regard to that bill? Anyone have any interest in an interim study motion on that?
What does it involve? Not that I mind, but I was just curious.
What, I'm sorry,
What is an interim study?
well, it means it's
I mean, I'm not
different.
stupid. I know what interim and study
Yeah,
is.
I mean, it basically is an alternative. I supposed to be completely candid about it. It is a softer alternative to ITL.
Okay. Kind of like lets people. Okay.
Right.
With respect, Mr. Chairman, is it not also the case that if we move interim study and that is the disposition, that there will in fact be some study meetings that are intended to figure out how the intent might be better addressed?
Well, I mean, there could be. In other words, we would have to at some point say whether we recommend it for further legislation or not. I mean, and you're right. That would be another difference. But anyway, anyone have any? I don't see anyone raising their hand, so I assume there's no interest in interim study. So in light of that, the chair recognizes Representative Kutab for a motion. Oh, Alexander.
Yes.
Sorry, Representative Alexander.
Thank you. I move ITL.
Is there a second? I'll second it. Hang on. Representative Alexander, you wish to speak to it?
Yeah, briefly. I think on top of some clear language flaws with the constitutional amendment, not a single person during the public hearing could give me a single example in which somebody has introduced a bill to take away the right to marry. There's clear Supreme case law that allows same-sex couples to get married. As a gay man myself, I'm not worried about my right to get married in the state of New Hampshire, and for that reason, I just don't think we need to enshrine it in the Constitution because there's absolutely no threat to it in this state.
Anyone else wish to be heard? All right, then I'm going to ask the clerk to call the roll. The motion is ITL on CACR 25.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
Oh, Birch.
Rep. Horrigan,
No.
Rep. Page, Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron.
Yes.
Motion passes
Wait,
10 to.
you-
Oh, Chairman Lind, sorry.
Yes.
Motion passes 11 to 7.
7. All right. Right. 11 to 7 ITL. All right. Representative Alexander, can you write the report?
Yes, absolutely. I'd love to.
All right.
Yeah.
Representative Lynn, I'll write a
Okay, all right, hang on. Let me just. Yeah.
Yes.
Yeah, I just, I'll.
Sander, minority, Rambo. And you will be OTP?
Yeah.
Okay. OTP. Okay. Sander and Rambo. All right, then next I'm going to turn to, hang on. HB 1547. The chair recognizes Representative Kuta.
Thank you. I move interim study.
Is there a second?
I second.
Right. Moved by Representative Kutab, seconded by Representative Perez. Right. Representative Kutab, do you wish to speak to your motion?
Just very briefly, this really expanded it way beyond what we had just passed last year, which was simply just for sexual assault. This includes simple assault and all kinds of other things. Basically, you wouldn't have any cases left in the circuit court. I think it makes sense for us to just take a further look at this and see what changes make sense, and also we'll have had time at that point to see what happens with this bill that was just implemented on January 1st. We'll data on that at that point. Thank you.
Anyone else should be heard? All right. Then let's call the roll on HB 1547. The motion is interim study.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Perch,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Page, Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lind.
Yes.
18 yeas, 0 nays.
Yes. All right. Any objection to it being on consent? Okay. Consent and Representative Kuta, will you write the report? Okay. Oh, I'm sorry. Kuta. Okay. All right. Next. All right. On, I am not going to exec HB 1639 now, we will have to exec that next Wednesday. I think that's an early, is that an early bill? I'm not sure.
Mr. Chair,
16:30.
so I just, so the committee knows and the public knows, I do have an amendment, and I believe it will drop the fiscal note down significantly. So even if it is an early bill, we might not even need to send it to finance if we pass it.
Right, and as I understand it, the basically it's along the lines of there will be some the provision saying that the training will be provided regarding grand juries.
Yeah, it might, I don't even think it's training. I just think it's like informing grand juries. So it could just be a sheet of paper.
Okay.
You know, I don't think it's going to be a significant expense.
Right. Okay. No, that makes sense. My sense is that we may be able to get a consensus on I mean, exactly, depending on exactly what the language says, but we may be able to get consensus. All right. All right. So next, I'm going to take up CACR 9, and I'm going to recognize myself for a motion of ought to pass, and ask, is there a second? Representative McFarland or Representative Bergeron, whoever. What?
Oh, I thought you were. I was saying that.
All right. So moved by me, seconded.
You did.
Oh, all right, seconded by Representative Bergeron.
Doesn't matter, really.
All right. And I don't really have anything further to say than what I said in my testimony. You know, I hope people will see things my way, but I understand that some people may not, and that's fine. That's fine. So, does anybody else have anything to say? All right. So I then ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Nope.
Rep. Tripp,
Yes.
Rep. Andrews,
No.
Clerk votes yes. Rep. Perez.
Nope.
Rep. McFarland,
Yes.
Rep. Scully,
No.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Page,
No.
Rep. Manos,
No.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron.
No.
You seconded the motion.
Okay.
So we can still vote that way.
So are you voting yes or no?
I am voting no.
Okay, so do you want to withdraw your second?
Sure. All right, so seconded by the Representative Bergeron's second is withdrawn, and Representative McFarland's second. All right. So, you know what?
Chairman Lynn?
I vote yes.
Okay, so the vote comes out 10-8.
10-8. All right.
10-8, what?
10-8. All right. I will write the majority. Is it gonna be a minority?
Joe Alexander.
All right.
Mr. Chair, I'll read it.
All right. Yeah, Joe.
The motion on the minority report, please?
Motion will be ITL.
Okay.
OTPA with the retirement age being 40. Is that what we want to do?
Right. All right, ITL. All right.
ITL, right?
All right.
This is 20, CACR 20 is next.
All right, next we'll turn to CACR 20, and the chair recognizes Representative Rombo for a motion.
Thank you, Mr. Chair. I move to ITL CACR 20.
I'll second that motion. Representative Rombo, do you wish to speak to the motion?
No, I don't think we need any further discussion. Thank you.
All right. Anyone else wish to be heard on CACR 20? All right, I'm ready for, ask the clerk to call the roll on. The motion is, on CACR 20 is ITL.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
No.
Rep. Scully,
No.
Rep. Ball,
Yes.
Rep Birch,
Yes.
Rep Smith, Rep Horrigan,
Yes.
Rep Page, Rep Manos,
Yes.
Rep Turer,
Yes.
Rep Rombo,
Yes.
Rep Bergeron,
Yes.
Chairman Lynn.
Yes, I'm sorry. I'm still on vacation. all right.
How old-
16-2, motion passed.
How old are you?
Yeah. Right, exactly. Good point. 16-2. 2. All right. 16-2.
Yes.
Okay. All right. So, Representative Rombo, you write the majority report.
Yep.
All right. And who will write? Representative Farland?
I can do that.
You write the minority. All right. McFarland, yeah.
So it's not on consent.
No.
1465.
No, we still have one more.
All right. Hang on.
1465. Una más.
Two. All right.
Yep, 3.
See, all right. Then, am I correct? The last one was 1465. Yeah. All right. Next, I'm going to turn to HB 1465, and the chair recognizes Representative Smith for a motion. And I will second that motion. Representative Smith, do you wish to be heard on your motion? All right. All right. Anyone else wish to speak on the motion of ITL on HB 1465? All right.
Establishing mandatory reporting of civil rights violations committed by members of
Right. All right, so I'd ask the clerk to call the roll. The motion on HB 1465 is ITL.
Vice Chair Mannion,
Yes.
Rep Alexander.
Yes.
Rep Tripp,
Yes.
Rep Andrews.
Yes.
Clerk votes yes. Rep Perez. Rep McFarland,
Yes.
Rep Scully,
Yes.
Rep Ball,
Yes.
Rep Birch,
Yes.
Rep Smith.
Yes.
Rep Horrigan,
Yes.
Rep Page. Rep Manos,
Yes.
Rep Turer,
Yes.
Rep Rombo,
Yes.
Rep Bergeron,
Yes.
Chairman Lynn.
Yes.
Motion passes 18-0.
18-0, okay. Consent.
What's the number?
And
Thank you.
Representative Smith, may I ask you to write the report?
Did you ask if everybody's okay with
Oh, yeah, I'm sorry. Is everybody okay with consent on 1465? Okay.
One question, Mr. Chairman, on that. If we voted in the affirmative, are we able to say we don't want it on consent?
Yeah, you can. You can take it off consent if you want.
Yeah, I'd like to do that.
All right, so no consent. All right.
you writing you can't write a report.
Right. All right, so there'll be no minority report, but, all right. So. All right. All right, well, this will.
Privacy.
What do you, I mean, why are you taking it off consent?
Because I believe that the intent is good, and that if the right floor amendment were offered, that we could find language that ought to be supported. I don't feel that well, I mean, I think there's two different questions you're asking, right? If you're asking me, am I submitting a committee amendment? No, because we just disposed of it. If you're asking me what happens on the floor, I don't know.
Maybe. All right. Okay, so I think that's it. So just so everybody understand, let me just repeat again. So we will not be having an executive session next Friday, February 6th. We will, however, have hearings on the 4th, and we will have to exec at least all of the early bills that are left. And I think there will be a few of them, including some that we're going to hear on the 4th. We'll have to exec them before we leave on the 4th. So for all of the people who have to write reports, can you have your reports to me by the end of the day tomorrow? Tomorrow. Is that okay? All right, great. All right.
You're free. You proofread?
Yeah.
Papers there? I'm trying to do 2 sheets in here.
Absolutely, and I'm sorry I didn't do that.
No, that's all right. I use a blank one. I use a white one so I don't make mistakes on it. I don't do the green one till later.
Oh, okay.
So I didn't need it.
All right.
But these here.
Are you ending the thing for the day? Or am I still on?
What's that?
Or do you want to end it for the day?
Oh.
Or am I still on?
Yep, no. All right, any other business that we need to discuss now? And I'm going to recess the committee. Thank you all.
Thank you. That's great to meet you.
Have a good weekend.
Thank you. Couldn't be happier.